We're going to call to order this December the 11th, 2014 meeting of the Alarm Systems Contractors Board. Ms. Smith, will you please call the roll?
I will. Scott Cockcroft.
Here.
Keith Harvey.
Here.
Vivian Hickson.
Here.
Karen Jones.
Here.
Mackenzie Roberts. Let the record show that Mr. Roberts is not in attendance, but we do have a quorum.
Have the board members had an opportunity to review our agenda for today's meeting, and if so, a motion to adopt?
Microphone, please.
Make a motion to adopt, Mr. Chairman.
Okay, we have a motion. Do we have a second?
Second.
If we have a motion and a second, all in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Also, in the iPads are the minutes from the October 16th, 2014 rulemaking hearing. Have the board members had an opportunity to review the minutes from this, and if so, a motion to...
Motion to approve the minutes as presented. Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockcroft to approve the minutes from the rulemaking hearing. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Next on the agenda are the minutes from the October 16th board meeting. If board members had had an opportunity to review these, then a motion to approve.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockcroft to approve the minutes as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Mr. Scudder, are you ready for the legal report this morning?
Yes, ma'am, I believe so.
Okay.
Good morning, Madam Chairman. Got a lengthy legal report today, and I'm just going to bowl through it until somebody lets me know that they need a break.
Is this on the iPad?
It's Exhibit A.
Exhibit, okay, thank you.
They might not have come out in order. I had trouble getting those loaded this morning, so.
Thank you.
If I'll have any questions, please don't hesitate to stop and ask me a question. First case on the report, the case ending in 4091. The complaint alleges that the respondent qualifying agent failed to list 2 alarm employees on their 2014 form, which is a violation of TCA 6232-317 and Alarm Systems Contractors Board Rule 0090-01-.069K. This is the first offense for this DQA. The recommendation is to authorize a formal and send a consent order to the respondent DQA with a civil penalty in amount of $100. This represents $50 times 2 employees for a violation of TCA 6232-317 and Rule 0090-01-069K.
I hate to start into lengthy questions, but it's real quick. Hopefully, the complainant, did this come about administratively or competitor, or did the company just call in and say, "Hey, I forgot to list these 2. They're still with us"?
It would be administrative.
Okay.
When we got the renewal
Most
out,
of those are like this, then.
almost all
All
the
right.
ones that are failure to report a termination or failure to register
Yeah.
an employee
That's
are
what
going
I
to be
thought.
administrative.
Staff
I
just
wanted to
catches
ask
it.
that question from last meeting, and I forgot.
Yeah.
I make a motion to concur with the recommendation of council.
Second.
Okay, we have a motion by Ms. Jones and a second by Mr. Harvey to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2, ending in 4121. The complaint alleges that the respondent QA failed to list an alarm employee on the company's 2014 renewal form in violation of TCA 6232-317 and Rule 0090-01-0.069K. This is also a first offense. The recommendation is to authorize a formal and send a consent order to the respondent DQA with a civil penalty in the amount of $50 for the violation of TCA 62-32-317 and the rule cited previously.
Motion, we concur with council's recommendation.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockcroft to concur with our council's recommendation. All in favor, voice by saying aye. Aye. All opposed? Motion carries.
Case number 3, ending in 4271, the complaint alleges that the responding qualifying agent failed to list 2 alarm employees on the company's 2014 renewal form in violation of TCA 62-32-317 and Rule 0090-01-069K. In his response, the respondent indicated that the 2 alarm employees had been terminated, and that was why they had been omitted. Their termination dates were June 25th, 2012, and January 9th, 2013. This is a first offense for this DQA. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $100, which represents $50 times 2 employees, to the respondent DQA for failure to file a termination notice in violation of TCA 62-32-317 and the previously cited rule.
Motion, we concur with council.
Second.
We have a motion by Ms. Jones and a second by Mr. Cockcroft to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 4, ending in 4361, the complaint alleges that the responding QA failed to file termination notices for 2 alarm employees in violation of TCA 62-32-317 and Alarm Systems Contractors Board Rule 0090-01-069K. This DQA received a $150 civil penalty in January of 2013 for this same violation. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $200, which represents $100 times 2 employees, to the respondent DQA for failure to file termination notices in violation of TCA 62-32-317 and the previously cited board rule.
Motion to concur with council.
Okay, we have a motion by Ms. Jones. Do we have a second?
What is our maximum penalty for that second offense?
Generally, it's I believe it's 50 for the first offense and 100 for the second offense, and then it goes 250 for the third offense, and that's per employee, not per incident.
When was the other incident?
In January of 2013, so about a year ago.
How did it come up? These didn't come up at renewal then, or these last 2 may have, but the one before wouldn't
This
have.
one would be, they finally turned the termination notice in a year later, a year and a half later, however long.
So they did turn it in. It
Right.
wasn't like it was caught at renewal where they hadn't done anything, so.
Exactly.
They were
They
truly
actually
late.
self-reported and put the accurate
Okay.
date on there.
Second motion.
Okay, we have a motion by Ms. Jones and a second by Mr. Harvey to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 5, case ending in 4401. The complaint alleges that the responding QA failed to submit transfer notices on 2 alarm employees within 30 days of their transfer, which constitutes a violation of 62-32-317 and Alarm Contractors Board Rule 0090-01-069K. This is a first offense for this QA. The The recommendation is to authorize a formal and send a consent order to the respondent DQA with a civil penalty in the amount of $100, which represents $50 times 2 employees for the violation of 62, 32, 317 in the previously cited board rule.
Motion we concur with council.
Second.
Okay, we have a motion by Mr. Harvey and a second by Ms. Jones to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 6, ending in 4411, the complaint alleges that the responding qualifying agent failed to submit a termination notice on an alarm employee within 30 days of the employee's termination, which constitutes a violation of Tennessee Code Annotated 6232-317 and Alarm Rule 0090-01-.069K. This is the respondent's first offense. Am I looking at the wrong?
Number 6,
Number 6 is the first offense, I believe.
ours says the 4th.
Okay. It is, that's a last minute edit. He has 3 previous disciplines, but for this particular offense, this is his first offense for this particular violation. I just got notification of that late yesterday afternoon.
So this is not his 4th offense for this violation.
This violation, this is his first offense. He has
Okay.
previous other things that he got disciplined for or had complaints filed against him for. But our complaint coordinator advised me, and I'm sorry I didn't get it to Beth in time to get the change on there. But it is his first offense for this violation.
The other's more stringent.
Don't recall exactly what they were for, and I thought I printed off the email, but I don't see it on here.
Beth, isn't that correct? Wouldn't we have normally have just said the number of offenses in the past, not off on a particular offense?
Well, again, if it's the same violation, that we would tell you there have been disciplined in the past possibly, but if it's not the same violation, I don't believe it.
Seems like if that's the case, we really shouldn't consider that other information. It wouldn't have been on there if,
Right.
And I can't remember exactly what they were for, but they weren't for misconduct. They were, paperwork type issues where they failed to get things in on time. Where they were allegedly harming the public or anything. Recommendation we recommend is a civil penalty in the amount of $50 for a violation of 6232-317 and Rule 0090-.01-.069K.
Okay, thank you. He just
Yeah, he
changed it
just-
because of this change up here.
Okay.
He modified it.
My mic. I make a motion that we go with council's advisory and mark it down to $50 for first offense on this violation.
second.
Okay, we have a motion by Ms. Jones and a second by Mr. Cockcroft to authorize the penalty in the formal and send a consent order with a penalty of $50 to reflect the updated violations. All in favor, voice by saying aye.
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 All opposed? Motion carries.
Case number 7, ending in 4441, The complaint alleges that the respondent QA failed to submit a termination notice on an alarm employee within 30 days of the employer's termination in violation of Tennessee Code Annotated 62-32-317 and Alarm Systems Contractors Rule 0090-01-.06-9K. In his response, the respondent states that he put in the date of employment, which was May 22nd, 2014, in the blank for the date of termination, and the date of termination, which was June 26, 2014, in the blank for the date of employment. In other words, he switched the dates. If he had put the dates in the proper blanks, his termination notice would have been timely filed in that it was received on July the 17th, 2014. This is his first offense. The recommendation is to authorize a formal and send a consent order to respondent DQA with a civil penalty in the amount of $50 for a violation of TCA 62-32-317 and the previously cited board rule.
Did we not believe that he was telling the truth?
Well, I guess I was just feeling vicious that day, to be honest with you. That's his job is to fill out these papers.
Right.
And you're not going to hurt my feelings if you change it.
Was the person registered? Was it that they had applied for registration? It was so quick, or
It was
No,
a notice
they-
of termination.
And he just got the hire date
And
and the termination date reversed, which to me, it's such a short period of time. Right.
If he had put them in the right blank boxes.
It can't be the way he has them
they'd have been-
logically.
Yeah, I mean,
so-
because he would have been fired before he was hired. But at the same time, I just didn't feel like it was my place to give him a break on that. I thought it might be better if that was done, it might be better for y'all to do that rather than me.
I just don't understand why
First
the employment
offense.
date and the termination date are so close together. Anyway,
Didn't stay long.
Yeah.
I mean,
Yeah.
but was he actually registered or applied for? Or
They have to turn in the termination notice whether they've been issued or not, so. But we've been processing a lot quicker unless they have some kind of criminal history that requires additional review with electronic fingerprinting. We're getting these things issued.
Would have been there 30 days without him registering him anyway.
Right.
So,
like he's really trying. If he registered the person within that time period when he didn't have to, and he.
I make a motion that we give him a letter of warning and blank form highlighting those boxes. That'll make you feel better.
He's already submitted a corrected form.
Okay.
In his response, he submitted a corrected form.
I make a motion we send him a letter of warning instead of a fine.
Okay, we have a motion by Ms. Jones and a second by Mr. Harvey to send a letter of warning in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Or her.
The person.
I think it was a he. Case number 8, ending in 4461. The complaint alleges that the respondent qualifying agent failed to submit a termination notice on an alarm employee within 30 days of the employer's termination in violation of TCA 62-32-317 and Alarm Systems Contractors Board Rule 0090-01-.069K. In his response, the respondent states that he sent the notice to their compliance department, and for whatever reason, the termination notice did not get mailed in a timely manner. This is the respondent's first offense. The recommendation is to authorize a formal and send a consent order to respondent DQA with a civil penalty in the amount of $50 for a violation of TCA 62-32-317 and the previously cited board rule.
motion to concur with council.
Second.
We have a motion by Mr. Harvey, a second by Ms. Jones to concur with our council's recommendation. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
Case number 9, ending in 4471, the complaint alleges that the respondent qualifying agent failed to submit a termination notice on an alarm employee within 30 days of the employee's termination in violation of TCA 6232-317 and Alarm Systems Contractors Board Rule 0090-01-.069K. In his response, the respondent states that the termination date was June 26, 2014, and he submitted an affidavit with his response that says, quote, on or about June 26, 2014, I deposited into regular U.S. mail a properly posted envelope addressed to the Tennessee Alarm Systems Contractors Board, and the envelope contained notification of the termination, end quote. The envelope was date stamped as received by the program staff as July 28, 2014. This is the respondent's first disciplinary complaint. The recommendation is to authorize a formal and send a consent order to the respondent DQA with a civil penalty in the amount of $50 for violation of TCA 6232-317 and the previously cited board rule.
Was it that 2 days would have made, or no, it wasn't 2 days, it was a month difference?
So he terminated him on the 26th, and he postmarked it the 26th, and it didn't get here till the 28th.
Of July 28th.
At first I thought it was
of
the same
July.
month.
Yeah, it was,
Yeah, me
June 26th, and he says he posted it June 26th, but it was July 28th when it was date stamped.
Are there any issues with, the mail, with it taking any amount of time to get to?
The envelope should have had a
Sometimes.
post.
We don't get the envelopes when they open the stuff in the cashiers in the. I have people call me all the time saying I mail my renewal in November and
Well, us paranoid people ask for a signature return card.
again, we don't have anything to refute what he said or.
And what was the termination date? Would it have been, were we talking that he was already at the end of his 30 days, or?
June the 26th was the termination date.
Was the termination, okay. So we're still
Not
only
30
a couple of
so
days
it's
out.
really only 2 or 3
Yeah.
days, so.
Because he had 30 days.
What about a letter to him?
I would make a motion that we send what is it, that we send
Letter
a
of warning.
letter of warning and without a penalty, or without a.
Okay, we have a motion by Mr. Cockcroft. Do we have a second?
Second.
Second by Mr. Harvey to send this person a letter of warning. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Let me reiterate, y'all not hurting my feelings but if y'all don't follow what I say. Y'all the ones with experience, and I'm still a new person. Case number 10, ending in 4481, the complaint alleges that the respondent qualifying agent failed to submit a termination notice on an alarm employee within 30 days of the employee's termination, which constitutes a violation of TCA 6232-317 and Alarm Systems Contractors Board Rule 0090-01-.069K. In his response, the respondent states that the employee in question had been having attendance problems and his actual termination date was July 28, 2014, rather than June 23, 2014, which had originally been written on the termination notice. The termination notice was received by the program staff on August 21st, 2014. This is the respondent's first disciplinary complaint. Our recommendation is to authorize a formal and send a consent order to the respondent DQA with a civil penalty in the amount of $50 for violation of TCA 6232-317 and the previously cited board rule.
Originally written that the termination notice was on June 23rd, but now he's saying it actually was July 28th.
Yes, sir. He was saying that the employee was he had health and attendance problems, and he was coming and going, and when he sent it in,
So if he worked there for a whole month.
I'm just trying to give you both sides of the story.
You're giving the information, and that's what we need. It's just up to us to.
The other thing is that they did send something in, and we've given this same amount to people that sent nothing in. That they sent a renewal in without it, and that's the only thing that troubles me on some of these is, they're making an effort, albeit late.
Change the recommendation then.
I would make a motion to send a letter of warning without the civil penalty.
Okay, we have a motion by Mr. Cockcroft. Do we have a second?
Now, is this saying that he was 2 months late? Oh, no, I just.
Date that it was on there the first time, it was only 30 days late, roughly.
Well, if you used the second date, he wasn't
Right.
late at all.
It wasn't late at all.
But if you used the first date, he was.
Saying that he returned to company property, the uniforms, what have you, on July 28th, and that his last paycheck was issued on August 16th.
Was the termination dated in June? I guess that's what I'm trying to ask.
But
And then
what do you, the termination that he
was
sent
dated
to
in
us,
June,
sent
but
to
he
the
didn't actually
staff.
quit till July, so it didn't get here till August.
That's correct.
So 30, 60 days.
Second motion.
Okay, we have a motion by Mr. Cockcroft, a second by Mr. Harvey, to send a letter of warning to this DQA. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 11, ending in 5121, the complaint alleges that the responding qualifying agent failed to list 5 alarm employees on the company's renewal form and also failed to submit a transfer form for one more employee within 30 days of the employee's transfer, which constitutes a violation of 6232-317 and Alarm Rule 0090-01-.069K. In his response, the respondent states that his employment was terminated with the company on June 18, 2014, and the renewal notice was received by program staff on June 9, 2014. This is the respondent's first disciplinary complaint. The recommendation is to authorize a formal and send a consent order to respondent DQA with a civil penalty in the amount of $250, which represents $50 times 5 employees for a violation of TCA 6232-317 and the previously cited board rule.
He was terminated on June 18th.
Yes, ma'am.
Fired him.
Yes, ma'am.
Not the QA.
Not the QA.
Yeah, the QA. Yeah, the QA. Was,
That's who he's talking about. We're
Yeah.
gonna
QA?
find
Okay.
the QA for something the company done.
yeah, the QA. Let me double check the.
No, it was sent on June the 9th. It was there
Yeah.
Yeah, the renewal notice got there on the 9th. I understand that. But on the 18th, they fired him. So he had 2 weeks. He couldn't. Can you? If you're not working for a company, let's say I'm not licensed under Keith. He fires me. I go to work for Vivian. I have no albeit power anymore, do I? I can't send termination notices in. So for 2 weeks, he couldn't. His hands were tied anyway.
I'm missing the.
Isn't he required to
The letter was
notify us
sent
as well of his
In the beginning
leaving?
of June.
Did he do that?
So in the middle, so he couldn't have terminated them people, knowing that he should have before the end of that month. He couldn't have done it if he wanted to.
Renewal notice was received by the program staff.
Yeah, but the owner says who goes and who stays. The QA really. Obviously, he didn't own the company or he wouldn't have got fired. I don't understand that one. I don't think he had enough time. Who turned it in?
It was administrative when we got the renewal notice.
And they're
So
new.
y'all received a
wait.
renewal notice from the company, and when y'all received it on June the 9th, it was missing these 5 things. But he didn't leave for 9 more days, so he was the one that sent, or should have been responsible for paperwork in pre-June the 9th, correct?
The QA is the one who sends in that notice.
Correct, and that
Yes,
was
ma'am.
all previous to June the 9th.
Yes,
But he wasn't terminated until June the 18th.
Who signed the renewal, him or the new QA?
Had to be him
Okay.
until the 18th.
So wouldn't we be
I was
fining the company for
backwards.
this?
Yeah, wouldn't you?
Well, I think the QA is usually considered to be the person that's responsible for maintaining the
QA 's the one that
paperwork
sent all the
and sending
paperwork
the
in
notices, transfer
June the 9th.
notices, and that type of thing.
In the
Already 9
past,
days later, so.
in the
Okay.
past, if you do find the QA though for something like this, haven't we been finding the company also?
I don't. maybe
Especially
I'm-
if they weren't the owner.
We used to. Probably close to a year ago, before Ed became the attorney.
Yeah, I agree. I was just,
Ask us to kind of.
I agree. It seemed to me though it was the company's. And it well enough. Let me go back and read it again. But
How
wouldn't the owner have told the QA, these are the people that I want?
But you're assuming something that's not in fact.
Yeah, I don't know.
You're assuming,
I don't think we have enough information,
no.
How long were the
especially if he's not
employees-
working there anymore.
the 5 employees in question? How long were they out of registration? They went to renew and they just simply weren't there to renew,
Weren't there-
basically.
They noticed, we've got all these new people that you haven't listed before. I don't have their dates of
We just
employment.
notified him at that point that you got 5 that's unregistered.
It's not unregistered, is it? It's 5 failed to list. There's 5 that were registered that weren't
register.
listed.
That's correct. They were registered. They had numbers and been issued numbers, but they weren't listed on the employee list of the
The
renewal.
company could have terminated them, and if so, the state didn't get the termination notices, or they could still be employed and they weren't renewed. Is that logical? But either way,
right.
5 people weren't renewed or terminated.
In his response, he says the employees listed are no longer employed at the company. I thought that their termination forms were sent in properly and obviously were not. I also was not informed of the hiring of the fifth person, and as a result, I did not know about the delay in the transfer form.
Large company, nationwide company, or just a small company? Well, he would have known if it was a small company, whether,
Multiple office or something, whether it's national or not. I guess he could have been supposed to be in the
Them.
the location.
But he was the DQA during this time.
I'm just trying to play devil's advocate. If my boss told me these people don't work here anymore, I wouldn't have put their name on the renewal form. And then if they had a bad separation, he decides, I'll get you. And he just,
They should, in theory, should know whatever employees are working there, if because it's by location, even if it's a large company.
It's the DQA's responsibility to know the coming and going of the employees. I would.
do, you really don't know what happened.
But you're just reading to us in his response. The response that we're hearing is from the DQA.
Yes, sir. Yes, sir. That's his response back to us in response to the complaint.
You gonna make a motion?
I'll make a motion to concur with council.
Do we have a second?
So you think he knew?
Do we have a second?
Well, I got second for discussion.
Okay.
You're assuming he knew. I'm gonna throw that word back.
He said he
Because
didn't
we're
know.
just,
These people were registered when he was
there.
there, whether they were there before he got there or not. He should have known I was
Job to
employed
know.
there.
I agree.
But if you're right, it's his job to know. But if they're not gonna pay him and they say you're fired, then he's not gonna re-register them.
We don't know all that.
Right. We're assuming he knew then.
Doesn't matter. They failed to send the paperwork in under his reign or under his leadership.
But if they were fired, he couldn't have. I'm still going to say that. If they were fired, he would have not sent the paperwork in, knowing that it's his license
But
to
he should
lose.
have. But he also should have terminated them. He would have, if they were fired, he should have known they were fired, and he should have terminated them. He did sign the renewal. I mean, he was the one that was on the renewal that didn't have them.
That little for renewal. So that couple of weeks is irrelevant.
Whether they were gone or there, either way,
It's the only one I have never understood. Plainly.
on the date that we received all the paperwork, or that the office received all the paperwork, he was still employed there, according to his own statement. He was terminated after that. So, I mean, he had to mail it long before he was
He
terminated.
said he knew that they were there. He did not.
They
Yeah.
were terminated, and he thought their termination forms were sent in properly, and obviously were not.
Wasn't his responsibility to submit termination notices?
If he's the QA,
It's,
if he's,
okay.
already had
Yeah, you did. I just said discussion.
And you, okay, we have a motion by Mr. Harvey, a second by Ms. Jones to concur with council's recommendation in this matter. All in favor voice by saying aye. Aye. All opposed? The motion carries.
Number 12, case number 12, ending in 7711. The complaint alleges that the respondent, qualifying agent, failed to submit termination notices on 2 alarm employees within 30 days of the employee's termination in violation of TCA 6232-317 and Alarm Rule 0090-01-.069K. In his response, the respondent states this was simply an oversight. This is the respondent's first disciplinary complaint. The recommendation is to authorize a formal and send a consent order to the respondent DQA with a civil penalty in the amount of $100, which represents $50 times 2 employees for violation of TCA 6232-317 and the previously cited board rule.
Motion to concur with council.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockcroft to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 13, ending in 2581, is a consumer complaint alleging that the respondent company was engaged in misconduct in violation of TCA 6232-319. The complaint states that the respondent's salesman told her that a neighbor's house had been broken into, which she later found out was that the break-in was in 2011. Her payments were $54.86 a month, which she found she could not afford. After contact by the board staff, the respondent reduced the payments to $29.99 a month, and additionally the respondent states that they made a pre-install call which went over the contract's terms again with the complainant. Finally, the complainant sent a letter to the board staff saying, "I agreed to this." And our recommendation is to close this case.
I'll make a motion to concur with council.
Could we include with maybe a letter to the consumer?
We have a motion by Ms. Jones to concur with council's recommendation and for Mr. Harvey to just send the complainant a letter from the staff attorney. Do we have a second on this?
Second.
A second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 14, ending in 9181, was a complaint that was referred to the board by the Attorney General's office. The Metro Nashville Police Department had been contacted by an employee of the respondent who claimed to be a whistleblower, quote unquote. He said he was moved by the respondent to Nashville to learn a takeover technique wherein representatives make contact with customers with existing security contracts and tell them they are there to, quote, upgrade their system, and in actuality change the system over to the respondent. The board investigators spent a great deal of time trying to locate the whistleblower, but they were never able to contact them. The only violation that the investigation could definitively substantiate was that the respondent had conducted some alarm sales activity before they had been properly registered and licensed. This respondent has three previous complaints, including number 13 that we just discussed. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $2,000 for engaging in the business of an alarm systems contractor without proper certification in violation of 6232-304A. Oh.
Make a motion that we authorize a formal consent order with a civil penalty of $5,000 for engaging in the business priors.
Second, did they pay their 3 priors?
Know that they paid one of those. The most recent, I'm sure the other 2 were paid. They're not pending, as far as I know.
One of them, I think you said we just
Well-
agreed to close, so that would be one of the 3, wouldn't it?
Yes, ma'am.
Including case number 13, so possibly on 2 of them they did. Okay. We have a motion by Mr. Harvey, a second by Ms. Jones, to authorize formal and send a consent order with a civil penalty in the amount of $5,000 for engaging in the business of an alarm systems contractor without proper certification in violation of TCA 6232-304A. All in favor, voice by saying aye. Aye. All opposed?
Opposed.
The motion carries.
Case number 15, ending in 2351, is a competitor complaint alleging unlicensed activity on the on the part of the respondent. The respondent advises that they are a scrap iron and metal dealer and not engaged in the business of alarm contracting. Our review indicated that this is not, or that there is, an unlicensed security business with a similar name and address. And our recommendation is to close this complaint and open a new one against the proper respondent.
I don't know how much question I can ask, but how close related are these that it could be confused?
Well, the family name is part of the business name, and they're on the same street or same highway, and so our staff, the board staff, sent it to the right place, the right name, and the right address. At least what these people are advertising on the internet. But for whatever reason, the post office sent it to these other folks, and they're the ones that say we're in the scrap iron metal business.
So there's a second location that is possibly operating that we need to address.
Yes, ma'am, and I don't believe that we could, because of the way that the meetings fall, I think we're going to have an investigation, and I don't think we can get it investigated and back to you all in time to keep this complaint open. So I think it'd be better to close this one and open a new one to keep it timely,
Okay,
moving timely.
I think I understand now. Y'all have any questions about?
I'd make a motion to concur with recommendations from our council.
Okay, we have a motion by Mr. Cockcroft, a second by Mr. Harvey to close this complaint, open a new complaint against the proper respondent. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 16, ending in 2551, alleges that the respondent company was engaging in misconduct in violation of TCA 6232-319. The complainant states that the respondent's representative told him that the respondent had bought out the complainant's existing security company. The respondent replaced his system with theirs. In their response, the respondent said that they did a pre-installation phone call, and the complainant stated he did not have an existing company and confirmed that he understood that this was a new system. Additionally, the respondent canceled the claimant's contract with them and waived his outstanding balance. And they will allow the the complainant to keep the equipment at no cost or obligation. Our recommendation is to close, as this matter appears to be a private contractual matter better handled through the court system.
Motion to concur with council.
Second.
We have a motion by Mr. Harvey, a second by Mr. Cockcroft to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 17 actually has 4 respondents. It ends in 4041, 4042, 4043, and 4044. This is a competitor complaint that alleges unlicensed activity on the part of the first 3 respondents in violation of TCA 6232-304A. The respondents state that they are a home theater, home automation, audio and video system, and central vacuum system installer. They do say in their contract, which they provided us a copy of, or at least that part, we have an arrangement with X, which is the 4th respondent, to provide a security analysis at no charge and then install, program, and monitor your system as you require. The 4th respondent, who is licensed, states that the first 3 respondents had, quote, has pre-wired the base of a system, panel, siren, and keypad, but he does not install the parts. So our recommendation is to authorize a formal and send a consent order to the first 3 respondents with a civil penalty in the amount of $500 for engaging in unlicensed activity in violation of 6232-304A. And also authorize a formal and send a consent order to the 4th respondent with a civil penalty in the amount of $500 for engaging in a joint venture with an unlicensed contractor in violation of TCA 6232-304E.
That for each, or is that all
500
together?
to each is
Okay.
what I was expecting.
Why are
or
there
anticipating.
3? Is it 3 individuals
Only
or is it a
$500.
company?
The way the complaint was set up was there was one individual and a second individual, and then those 2 as a company, and then the 4th is the licensed entity that's working with that company.
Possibly consider the 2 individuals, that is the company, as one.
Could do it that
I'm
way.
not opposed to it being more than 500, but I think we ought to look at it as the entity of the company, and I don't think.
So the respondents are almost in a
Partnership.
partnership
Right.
together.
In their contract, like when they, submit a contract they've got, well, we have this special deal with this licensed party over here. And then when somebody says, yes, I want a security contract, then they pass the ball off to the licensed party. But then the licensed party says in his response that they're pre-wiring bases, panels, and
Actually
sirens
doing
and
work, yeah.
keypads.
They're wiring it,
That's
they
not
have to be
parts,
designing the
what is it,
system.
I
macaroni?
was going to say, what parts are left, So we have like 2 people. I mean, we have
2
2
people.
entities.
2
A
companies.
group
Like,
an unlicensed and a licensed.
X and
I agree
Y
with
are the
Scott
2
on the-
individuals, and then
Yeah.
they have like XY company, and then they're working with a licensed individual.
Aren't there amounts in the statute for
1,000 to 5,000 on your discretion.
And then the other is for the licensed person, I mean, they're engaging in a joint venture, are there amounts for that or is that still unlicensed activity? If it's falling under the same thing, or?
It's joint.
Venture is a separate thing.
And the unlicensed companies is gonna learn.
I don't have a problem. I'd like to see us join the one entity, the 2.
Close it against their business entity and just have it against those first 2 individuals.
I would think we would be better to go against the business entity and close it against the individuals.
I don't understand why we're only gonna fine the licensed company $500 when he knows better, and we fine the previous company $5,000 for the same reason.
The other was some different misconduct. I thought we had others that were $1,000 or $2,000 for unlicensed activity.
Going in and taking over systems and saying, we're here to upgrade you. But this guy here is,
You just marked it 500 because it was the first offense, right?
Or a matrix that has been developed over time, and I try to follow that as much as I can. But sometimes
he was working
allowing them
unregistered
to
people.
wire it. He knew what was going on.
They were wiring. Letter to the respondents that are pre-wiring about licensure with $1,000 civil penalty, and they can come in and talk to us, and then we can explain it to them more, and then we send a $5,000 civil penalty to the licensed contractor who knew what these people were doing, and he was getting by without having to register any of them.
What amounts did you say again? 1,000 to?
To the
1 and
first group,
5.
and 5 to the licensed contractor.
When we say have them come in and talk to us, do they really have an opportunity to come versus
Yeah.
a formal hearing? I mean, 'cause
Yeah.
Yeah.
they
Do
could
that all
come,
the time when we,
they could come
Got
up
4
here.
today.
yeah. That's the final, or the formal hearing is kind of the last step before the board.
not sure in the legal side that we have a forum for them to come in and discuss before the formal hearing. I don't know, there may be something being done informally. But as far as I know, we give them a consent order, and it's a take it or leave it, and if they decide not to take it, it goes to a formal hearing. Now, there may be something done informally that I'm not aware of, but as far as I know, formal hearing is the forum for them to tell their side of the story.
Past, they've asked our attorneys, can we discuss this?
They would come in front of the board and
We don't.
Well, I think what we're thinking about is where we deny people on their registrations and so forth. We allow them to come before the board, but
Is
Right.
one of-
Not all they can do is come back and say, I don't want to pay this, and then he has to represent it to you guys.
And because y'all would have to recuse yourself, if somebody come, like John Smith came up here and talked to you about his case, then y'all would have to recuse yourself when you actually had a formal hearing, because y'all would consider to be prejudiced on that. That's the reason we don't put the names on these,
I think there was a
complaint
case
reports.
where somebody was before y'all here, but it had unlicensed activity, but it was about them getting registered at that particular point in time.
I don't doubt it. I don't remember it.
But I didn't think there was a way for them to come other than a formal hearing.
I'm just going on what happened.
To have that, he has to send the consent order, then they have to come back and ask for an informal conference. And then we have to find one board member that can recuse themselves because they will have privileged information. responded, and then come back and make a new recommendation to the board. Very rare, but we do, but they have to specifically ask. That board member has to abstain.
Well, no, she has a motion to,
I don't think she.
I didn't think you actually made a motion.
did you,
I made a motion.
Okay.
yeah, because she
And
put
a
it
letter
for,
of instruction instead of warning, instruction on licensure to respondent A,
to A, and
the-
then,
the pre-wires, and a $5,000 penalty to the license company.
I think that penalty is a little steep on this particular.
How long have they been in
5,000.
business?
because the first,
Quite a
her
while,
first was
But
1,000,
they
and
have
her
two
second for the
employees.
company
It's a
was
very
5.
small company.
I don't have a problem with 1,000.
Yeah, that's what I was thinking, was 1,000 to each company.
Okay, I'll amend my motion to 1,000 for the first company and 1,000 for the second company.
With the letter.
Still
of
with a letter of
instruction.
instruction to both.
I'll second that.
Okay. We have a motion by Ms. Jones, a second by Mr. Cockcroft to authorize a formal, send a consent order to the first company consisting of the 3 respondents with a civil penalty in the amount of $1,000 for engaging in unlicensed activity in violation of TCA 6232-304A, and authorize and send a consent order to the licensed, which is listed as the 4th respondent, with the civil penalty in the amount of $1,000 for engaging in a joint with unlicensed contractor in violation of TCA 6232-304E, and a letter of instruction to each of these. All in favor, voice by saying aye. Aye.
Aye.
All opposed? The motion carries.
I'm understanding you, we're gonna just close the 2 against the 2 individuals that work for the first company, and just that $1,000 against that,
That's
to the company.
correct.
Okay. Okay, I thought that's what you meant, but I thought I better make sure.
Oh, that's correct.
Case number 18, ending in 4281. The complaint was established against the respondent alarm company when the board office received applications for 2 employees that were not within 30 days of their employment date in violation of 6232-312. The date of employment for employee A was June 30th, 2014. The date of employment for employee B was March 28, 2011. In their response, respondent states that employees' registration was filed with the board office in June 2014. What was denied when he failed, their employee A should be there. That A's been dropped out. I apologize for that. Employee A's registration was filed with the board in June 2014, but was denied when he failed to provide court disposition paperwork to the board office. He states that employee A was transferred to Louisiana in July and has not returned to Tennessee. He states further that employee B has been employed by the respondent since March 28, 2011, but was not transferred to Tennessee until March of 2014. His application was filed on September 2014. This respondent has 5 previous disciplinary complaints. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $4,200. This amount represents $300 times 6 months for employee A, plus $300 times 8 months for employee B. And this penalty would be for failing to register employees within 30 days of employment in violation of TCA 6232-312C. Looking at the paperwork, they he, let's see, employee A.
Colorado.
They filed, he was denied, and they
Denied,
transferred him.
and so they transferred him to,
So-
but then they listed him as an employee. Or, excuse me, they received an application.
We have a lot of companies that put the original hire date for these people, and they may be out of and then reapplied, which happens a lot, and they put the original hire date on there.
Truth about that. But I mean, he's responsible for doing the paperwork, and he listed that person or as an application, and so question as to whether or not.
Let me ask this question.
Sure.
When was employee A hired by the company? Because I'm trying to figure out the 6 months for employee A.
Employee A, his date of employment was June 30th, 2014. I can read you from his response.
Okay,
It says,
no, let's stop
Okay.
right there. You say this amount represents $300 times 6 months for employee A. Where's that 6 months? If he went,
I was still charging him 6 months for not advising us, for not telling us.
That's all we really know at that point. He transferred him to,
We didn't, yeah.
we've got employee B. Was transferred to Tennessee in March of 2014.
Got his
Art.
application in September.
So he worked 6 months before they submitted his
It's March 14th, yeah, that would be 6 months.
that's the question I have on that is 300 times 8 months. If he sent it in, that would be 6 months, I think.
really
5
5 months.
months.
Well, I don't think it was a transfer, he had to reapply. 30 days either way, so, yeah.
When he transferred him to Tennessee, he had 30 days to get his paperwork in, which would make. So we're down to like 5 times 300, correct? Do y'all agree with that?
And is 300 an amount based on
Pre-
the previous violations and what's set up for this offense?
First offense is what, 100 per month?
They are licensed now, or, I mean, they are registered now, or is that?
Again,
maybe that's
yeah.
Well, it would actually just be the one if we take him at his word that the other one would. He did send employee B's paperwork in September.
would make a motion that we charge employee a civil penalty of $1,500, 5 months times $300 penalty.
Company,
Because of
the,
employee.
the company, because of employee B is, I think,
Exactly.
yeah.
Yes. Concerned about the other part of this in that motion, so that would be the.
But we never voted on that. That was just the recommendation, so we're gonna
Right.
ignore that and form our own recommendation.
Exactly.
Okay, we have a motion by Mr. Harvey. Do we have a second?
I'll second.
Okay, we have a motion by Mr. Harvey, a second by Ms. Jones to authorize formal and send a consent order with a civil penalty in the amount of $1,500. This represents a civil penalty for $300 times 5 months for employee B for failure to register employees within 30 days of employment in violation of TCA 6232 312C. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
So did we deal with A?
No, because there's no violation.
That's all I was asking.
Okay.
We weren't still doing anything with it.
Case number 19, ending in 4291. The complaint was established against the respondent alarm company when the board office received applications for an employee that was not within 30 days of his employment date, which constitutes a violation of TCA 6232 312C. The employee's date of employment was April 18, 2014, and the application was received August 25th, 2014. This is the respondent's second complaint for this sort of infraction. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $400, which constitutes $200 times 4 months the employee worked in violation of TCA 6232 312C. Item 4B, 8, yes.
Okay. We have a motion from Mr. Harvey to concur with our council. We have a second by Ms. Jones to concur with council to authorize formal send a consent order with the civil penalty in the amount of $800. This would represent $200 times 4 months when the employee worked in violation of TCA 6232 312C. All in favor, voice by saying aye. Aye. All opposed, the motion carries. I don't know, I can't.
Case number 20, ending in 4381. The complaint was established against the respondent alarm company when the board office received applications for 3 employees that were not within 30 days of their employment dates in violation of TCA 6232 312. Employee A's date of employment was 8/5/2013. Employee B's employment date was 3/17/2014, and employee C's employment date was 6/2/2014. Their applications were received in the board office on September 4th, 2014, and September 10th, 2014. The respondent states that employee A had planned to work in Tennessee, but instead moved to Colorado.
Wait, which occurred in what month? You said they were received. Which one, A, B, or C?
They were,
You got 2 arrival dates.
okay, let me get the,
Six days apart. They're both September 14.
What you got?
Oh, I just got those two dates listed. Oh, here we go, here we go. Employee, yes, ma'am, of 2014. And employee C was received September 10th. Respondent states that employee A had planned to work in Tennessee, but instead moved to Colorado. He states further that employees B and C worked exclusively in training up until the date of their application. And this respondent has no history of disciplinary offenses. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $450. This represents $300 for employee A, $50 times 6 months, $150 for employee B, that's $50 times 3 months, and that would be for a violation of TCA 6232-312. Let me read that. It looks like there has been a
We're
typo
missing-
here. Employee C.
Yes.
Employee, let's see, employee B was 6 months times $50. Employee A was never in Tennessee, and employee C was 3 months times $50. So 300 and 150 would be 450.
So you're saying that employee A, they actually sent employee registration application in for employee A in September of 2014, and he was hired in August of 2013, but he never worked in Tennessee.
That's what the respondent is
Why did we
So
saying.
why did
receive-
they send it in if he never, was that your question?
Yeah.
Why did they even send it in if he never worked in Tennessee?
They said that employee A had worked for the respondent since August 5th, 2013. However, he was not working in Tennessee during that time. He was going to be working on upcoming projects for us in Tennessee. Since we sent in his application, he has been relocated to Colorado and will no longer be working on any future Tennessee projects.
My question is, where was he from 2013 until September of 2014?
Is that what they're saying, that he transferred to Colorado then in 2013?
Why would they have,
Wow.
why would they have ever sent the application in?
That's
It
the
sounds like they
question.
sent the application in and then
Company's located
subsequently
in
transferred.
Missouri, so
This company what?
they're located in Missouri. So could very well be that he worked for them in Missouri, and that was his hire date.
What did they have you do with employee A's application?
Their complaint, they said, if you can cancel his application and return his documentation to us, we will terminate the application process for this employee.
First offense on this, it says no history of disciplinary offenses. I take that to be.
They have some national contract and they come in.
People have definitely been confused on what date to put, whether it be the date of employment or the date in the registered position, because they could have been employed there for 5 years, but not.
I think we're mainly looking at employee B and C, is that correct? We've pretty much excluded A. And then we need to change in the recommendation, that should be changed from employee A to employee B, and employee B should be changed to employee C. Recommendation, if that helps.
Problem with that. You're saying to send a letter of warning with, there seems to be a lot of confusion on when they really started in Tennessee or whether they did or what, or.
Because we don't have any proof that employees B and C did anything other than training during the period that we've got set aside for fining. Is that correct?
They are, in their response, they say that employees B and C were exclusively working and training in all aspects of machines up to that date we applied for the alarm systems license.
Send a letter of warning to this company in reference to.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockcroft to send a letter of warning to this company regarding proper employee registration timelines. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
Case number 21, ending in 5991, is a consumer complaint that alleges that the respondent company was engaging in misconduct in violation of TCA 6232-319. The complainant states that the respondent's representative installed 2 cameras in her home and switched her over to the respondent's service. The complainant said that there was a misunderstanding and she felt like she was being rushed into the installation of the monitors. She states, quote, "They lied, promised money at door, and I was already with another company," end quote. From looking at the file, it's not exactly clear what the respondent said, or excuse me, what the complainant said that the respondent was lying about. But the respondent stated in their response that they have canceled the complainant's contract, which was what the complainant was wanting to have done in the first place. But this respondent has 24 previous complaints for various matters. But our recommendation is to close this case, as this matter appears to be a private contractual matter better handled through the civil court system.
Motion, we concur with counsel.
Second with the question. It says the complainant states that the respondent's representative installed 2 cameras and then switched her over to another respondent. So there's 1 complainant and 2 respondents?
There was just 1 complainant and 1 respondent.
He had
To
service
theirs.
A, and they put in 2 cameras and switched her to service B. And okay, we have
Second,
a,
I thought there was 2.
okay. We have a motion by Mr. Harvey, a second by Ms. Jones to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 22, ending in 6021, is a consumer complaint that alleges that the respondent company was engaging in misconduct in violation of TCA 6232-319. The complainant alleges that the complainant's security system was broken and that the respondent told them that lightning had struck their sensor and they needed a new sensor. Respondent offered to sell complainant a new sensor for $380 and insurance on the system for $40 a month. The complainant alleges that when they phoned the respondent, he yelled at them and hung up the phone. The complainants want their contract canceled. The respondent has no history of disciplinary action. However, they did not respond to the request for a response from the board staff. So the recommendation is close in regard to the contractual claims, as this appears to be a private contractual matter better handled through the civil court system. And also authorize a formal and send a consent order with a civil penalty in the amount of $100 for failure to respond to a board complaint within 20 business days in violation of Alarm Systems Contractors Rule 0090-01-.0714.
I make a motion to concur with our recommendations from council.
We have a motion from Mr. Cockcroft. Do we have a second? Second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 23, ending in 6741, is a consumer complaint alleging that the respondent company was engaging in misconduct in violation of TCA 6232-319. The complaint alleges that after years of service, he opted to a month-to-month contract with the respondent. The complainant states that his system stopped working and he telephoned the respondent to request repairs. He states that no repairman came and he canceled his service, but the respondent continued to bill him. He requested that his monitoring agreement be canceled. In their response, the respondent states that the complainant did not give them enough time to have a repairman there. They state that they had told the complainant somebody would be there in 24 to 72 hours, and they indicate that they would have had the repairman there on the 3rd day. They have canceled the complainant's contract, which is the relief that the complainant sought. The respondent has 5 previous complaints. Our recommendation is to close this, as this appears to be a private contractual matter better handled through the civil court system.
Motion to concur with council.
Second.
We have a motion by Mr. Harvey, a second by Mr. Cockcroft to concur with council in this matter. All in favor, voice by saying aye. Aye. All opposed, the motion carries.
Case number 24, ending in 7111, alleges that the respondent company is offering to perform fire and monitoring work when they are only certified for CCTV and burglar alarms. They also printed another license number rather than their own on their advertising materials. This would constitute a violation of TCA sections 6232 316D and 6232-316B. And also of Alarm Rule 0090-01-.07. In their response, the respondent states that they used artwork that had belonged to the business's previous owner. They state that although fire service was offered on the artwork of the advertisement, they never actually performed that type work. They state that they do not believe that the advertising materials were ever distributed to the public to their knowledge, and they apologize for any misunderstanding. They were disciplined in 2012 for using the wrong certification number in an advertisement. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $1,000, which represents $500 for displaying the wrong certification number on advertising in violation of TCA 6232-316D, as well as $500 for offering to perform installation work for which the party is not certified in violation of TCA 6232-316B and rules of the Alarm Contractors Board, Rule 0090-01-.073.
Second time doing this.
What are they putting on there? Are they putting someone else's license number? Or are they putting a QA number? I mean, are they just putting a random number?
They've bought a business from a previous person,
So they may have some
And-
old paperwork that
and
has
they what they're putting out there is the previous person's certification number.
Also done it previous to this, which is constitute a pattern.
And how did the complaint, they said it never went out to the public, but somebody saw it. Somebody got it.
To their knowledge. I make a motion that they get a $1,000 fine for each instance because it's their second occurrence and not their first. I think 500 would be okay for the first offense. I don't know what they were fined the first time. But we've got to get their attention somehow. If they're on doing it.
So you wanna fine them 1,000 for displaying the wrong certification number and 1,000 for offering to perform installation services?
For hanging out their shingle in a classification which they're not licensed for.
I'm just curious. The license number they're using is licensed for fire.
Yeah.
Jones to authorize a formal and send a consent order with a civil penalty in the amount of $2,000. This amount represents $1,000 for displaying the wrong certification number on advertising in violation of TCA 6232-316D, and $1,000 for offering to perform installation of service for which the party is not certified in violation of 6232-316B, and Alarm Systems Contractors Rules 009001-.073. Do we have a second?
My question is, what is our maximums and minimums on those violations?
Well, we've got what we've used, there's sort of a matrix that y'all have developed
What's
in
the
the
maximum
past.
on the matrix?
Up to 3,000 on the, let's see.
Where did the complaint come from if they don't think it was ever circulated? Was it?
And that complaint provided the number, the certification number?
Document or whatever?
Copies of
They've seen it.
the advertisement.
But it could be a former employee that took paperwork, something out of the, if it's somebody that's anonymous isn't, putting forth, if it was a consumer that felt like they'd been wronged, I wouldn't think they would be anonymous.
By statute, y'all can go all the way up to 5,000.
Well, up at the very top was that one for the 316. I think you,
Other said failure to put the other was licensed, but they didn't put their number on there, and this is putting the wrong number. Seems worse than that, so.
Well, again, and it's the second offense, so if you want to use your standard penalty. I ever send you a copy? I did send you. I will, so. Anyway, second offense is only 500 for failure to display the certification number, but it's up to you guys.
I think
They're
this
not
is
failing
different.
That's not,
Listing the wrong, I know, but this is all we have in
Right.
the standard.
that's just failing
You
to
go
put
by
on
the
there
other
what you
one that
got.
was in the, that they were engaging in the business that they weren't licensed for. That was higher, wasn't it? That was,
we have a motion. We have a motion by Ms. Jones. We're just waiting for a second on.
My only question was the dollar amount. I'm good with the motion.
Motion on the floor is to increase the penalty to $2,000, which is $1,000 for each violation.
That's correct.
I'm fine with $1,000, but I don't think we need to, I think it's the same. As far as the engage, well, this is referencing the license versus the displaying the wrong license and engaging in the. What's the current motion though?
rules. It's
The
kind of
motion-
like two companies working unregistered for 3 months.
Initially,
You're
it
fined
was
for
a total
both.
of 1,000 with 500 for each violation, though using the wrong certification number and advertising to do fire, which they're not certified to do. Her motion is to double the civil penalty to $1,000 for a total of 2,000 on the offenses.
We're really still talking about one thing. We're talking about the advertisement.
And the certification numbers.
Right, but they used it in the advertisement. They used the wrong certification in
But
the
they're also,
advertisement.
but they're advertising for fire, I thought, unless I missed something. Where's,
It is
You're
that
right,
number,
You're right.
and I said, is it their first time or
they,
second time?
they were advertising, or they put fire service on their artwork, and they're not registered or certified to do fire, so that's what the two violations are,
And this is the second complaint. the
for
same
using
thing.
the wrong certification number. No certification, just using somebody's that is fire certified when they're not fire
I think it's a
certified.
fine line, but I'm with you. I'll second the motion.
Okay, we have a motion by Ms. Jones and a second by Mr. Harvey for the previous read into the record increase from $500 to $1,000 for displaying the wrong certification number and for offering to perform installation of a service for which the party is not certified. TCA and the rules. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
Case number 25, ending in 7131, alleges that the respondent qualifying agent has continued to work as a qualifying agent after his license expired in violation of TCA 6232-304K and 6232-317A. His license expired on May 31st, 2014. The board office received a renewal form signed on September 12, 2014, and received in the board office on October 8, 2014. The board sent a letter on the same day, that is, October 8, 2014, advising the QA that he would have to reapply. After 3 months, because after 3 months, the DQA must reapply pursuant to TCA 6232-313J. He has attempted to renew, but has not reapplied as instructed. I need to amend that. I found out after this was printed that he reapplied on November 5th, 2014. He does not have a history of disciplinary actions, and so the recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $2,500, which represents 5 months times $500 per month for violation of TCA 6232-304K and 6232-317A.
Hey, did the company that he was the QA for, did they acknowledge that that their QA was it? Okay.
He was, I think, if I'm not mistaken, let me make sure.
Asked for an extension to get him reapplied?
Like an employee. He was not.
He
their
held a
designated.
QA license, but he was not the DQA for this particular company.
I think that's considerably different.
Yeah.
Yeah, again, it's like working an unregistered employee.
Happened to hold a QA license. So what's the problem?
Did their DQA quit?
Working ever since it expired without anything. They didn't apply for registration or anything else. They just kept.
He would have. He would have just been like working an unregistered employee for.
How long has he
3
had his
months.
license?
We're gonna charge him $25.
No, I want to know how many years he's been renewing it, and all of a sudden he just up. That crawls around in the back of your head all the time. You got to do it every 2 years. But if you
the
hold
law
a
says any
QA,
qualifying
renew
agent has
QA.
to reapply if they don't renew
Because
within
his
3
QA
months.
license.
Yeah.
He has been licensed for a while. I think he transferred to. If you want. I mean, the law's very specific that he cannot work on an expired license. It becomes invalid the day it expires, and he's not to continue to work on an invalid.
Wasn't working as a QA. He was just
Working as an
working
alarm
as
well-
a registered employee.
Right. Well, working.
license.
Right.
I look at that completely different.
Well, but he had, either way, he was working, he knew he had to have one, he's taken the QA test and everything else.
saying that-
Generally, you guys are a little bit more stringent on people that have a qualified agent license because
he knows
of
the
what they had
laws.
to do to get it, so.
Right.
That's why I asked how long you'd had it. Had his QA.
But in
So
reality,
he was out of the 3 months even when he first sent his renewal in.
Oh, yeah,
So,
that's
I
why we
mean-
denied his renewal. And we'd already
See,
sent him a
he
letter
was
saying,
out.
hey, you don't have a license.
And then after how long you have to retest?
Well, that's not, either way, you still gotta reapply, go through another background check. Whether you have to retest or get the training again, usually we don't make them do that, so. But he didn't have a license at all from the date it expired. And I don't know that we've issued it yet because of this complaint, so, but he does have an application on file.
still be hold a QA license, but not be working as a QA.
No,
Just-
his QA expired. I mean, the whole license expired.
No, you're not. You and I both could be a QA for ABC company. You could be the D.
If he wants to be a QA.
But he
Period.
sent
But
his-
if he wants to work for this company, he's either gotta apply for employee registration or renew his
Right.
QA license. And
gotta
he didn't,
renew
they
something.
didn't
Do
do nothing.
either.
I'm with you on that,
Okay.
100%. But it's as if we're
You're confused on the DQA.
charging him for the maximum when he really could be only guilty of the minimum. He really could only be guilty of just being an unregistered employee.
Well,
If you hold a QA license,
see, we would hold the company responsible for that,
And the next complaint's against the
is
company.
against the
Yeah,
company.
it gets more interesting with the next one. It's,
Again, he neglected to renew his license when it expired.
I think we ought to treat the amounts based on it being an employee operating unregistered though, not. What would those amounts be?
held to a higher standard.
We don't have standard amounts to find the employee that's not registered, we find the company. I think we have fines for the QA, and it doesn't matter if they're the DQA or not. But let me look.
The company that's letting him continue to work unlicensed, he's,
So,
They don't care.
TCA 62304K, qualifying agent, doesn't say designated, continued operation with invalid license. First offense, $500 a month. Second offense, $2,000 a month.
Have an employee that's a QA.
Fine for that.
I can have an employee that's a QA that is not my DQA. I don't care if he's a QA or not. I can have 18 of them.
They all got to keep them up.
They gotta renew their licenses.
Or
to
the
keep
register,
working.
or they need to be just registered.
Right.
but they weren't. Which to be, he would have had to.
He would have
become
had
a
to
registered
apply for employee registration at the time his license expired, which he had an
In this
option
case, he
to
didn't do either, so there's clearly a violation. I'm
Right.
just looking at the penalty involved.
And that's the minimum.
I mean, the statute's very specific.
I'm with you.
Not like we didn't send a notice.
I make a motion that we concur with council.
Motion by Ms. Jones to concur with our council's recommendation. Do we have a second?
I don't know if we have the latitude to do something different.
Standard penalties are suggested, they're not mandated by statute.
$500 is the minimum.
500 is
Okay,
what
yeah,
we
that's
set
what I
up in
thought.
our standard penalties
Yeah.
when we develop those. That,
I was involved in that. I think that the thought behind that minimum penalty was that QA was active QA.
License.
Nothing really.
but the
Yeah.
law's real specific that
Yeah.
you cannot continue to be employed on an invalid license. But the standard penalties are flexible because they're not in the law or the rules.
The guy has been trying to get back straight with the world.
I don't know exactly, but it's not,
I'd be more
it's not
comfortable with
recent.
$1,000.
Where are we on this, though? Did that motion
So her motion's gonna
fail?
die for lack of a second at the $3,000. Then we need another motion with a,
I would make a motion to authorize a formal and send a consent order with a civil penalty in the amount of
okay, we have a motion, Mr. Cockcroft, to authorize formal, send a consent order with a civil penalty in the amount of $1,000. This represents 6 months times,
5 months.
oh, I'm sorry, 5 months
Times
at $200 per month for violation of TCA 6232-304K and 6232-317A. Do we have a second?
I would feel completely different about this if this were the DQA we're talking about. And I understand he's still a QA and he's still responsible for it, but I second the motion.
Okay, and we have a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
Aye. All opposed?
Nay.
Okay, we have one opposed. I think the next case is relative to the same one.
Yes, ma'am.
Okay.
It's the same case, except this is a complaint against the company. And their response was that he was not their designated qualifying agent, and that their designated qualifying agent is duly licensed, and his license won't expire until March 31st, 2016. However, they did allow the respondent in 25 to work without a license. This respondent has 2 previous complaints, one of them in 2005 for working an unregistered employee. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $700. This amount represents 7 months times $100 per month for violation of TCA 6232-312C. Oh, I forgot to amend this one.
Actually got changed to 5 months on the previous 5 times the 200.
I would concur with council on the 5 months.
second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockcroft, and this is authorized formal, send a consent order with a civil penalty in the amount of $500. This amount represents 5 months times $100 per month for violation of TCA 6232-312C. All in favor, voice by saying aye. Aye. All opposed?
Nay.
One opposed. The motion carries.
Case number 27, ending in 7145. 41 alleges that the respondent alarm company failed to display the company certificate number in correspondence that was submitted to the board office in violation of TCA 62-32-316D. In its response, the respondent states that this was an oversight and has corrected the issue. This respondent has no disciplinary history. The recommendation is to authorize a letter of warning for violating TCA 62-32-316 and then close the case.
Motion we concur.
Second.
Okay, we have a motion and a second concur with council's recommendation. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
Case number 28, ending in 7671. The complaint alleges that the respondent alarm company was advertising to do alarm work without holding a valid license in violation of TCA 62-32-316D. The respondent submitted their application on August 15, 2014. The flyer advertising to do alarm work was placed on the complainant's door on September 14, 2014. The respondent's application was approved on September 24, 2014. In its response, the respondent states that the advertisement was placed in anticipation of the application being approved and that they were maintaining contact with the board staff throughout the application process. And the flyer was a scheduling and coordination error, and they have no history of previous discipline. The recommendation is to close as they're less than 15 days from the alleged violation to the approval of their application.
We have a motion by Ms. Jones, a second by Mr. Harvey to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Harvey.
Next case, case number 29, ending in 7701. The complaint alleges that the respondent alarm company failed to display their alarm contractor certification number on correspondence sent to the board concerning 2 employees in violation of TCA 62-32-316D. In its response, the respondent states that this was an oversight and is working to correct the issue. This is the respondent's first discipline for this sort of infraction, and although they do have a previous discipline for failing to register an employee for 30 days, within 30 days. The recommendation is to close with a letter of warning for violation of 62-32-316D.
I make a motion to concur with recommendation from council.
Second.
Okay, we have a motion by Mr. Cockcroft, a second by Ms. Jones to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 30, ending in 8301. The complaint alleges that the respondent alarm company failed to display their alarm certification number on correspondence sent to the board concerning, did I just see?
This is another one.
Same thing.
Okay.
It's Groundhog's Day.
Concerning 2 employees. In its response, the respondent states that this was an oversight and has corrected this issue. The respondent has no previous disciplinary history. The recommendation is to close with a letter of warning for violation of TCA 62-32-316.
To concur.
Second.
We have a motion by Ms. Jones, a second by Mr. Cockcroft to concur with our council's recommendation. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
Case number 31, ending in 2591. This is a competitor complaint alleging that the respondent alarm company is engaging in misconduct as defined in TCA 62-32-319. The complaint alleges that the respondent is employing its employees as independent contractors and issuing them 1099 tax forms. However, it does appear that they are still listing the employee on the employee registration form that they submit to the board office. The respondent has a lengthy disciplinary history with more than 20 previous complaints. Our recommendation is to close the complaint, as it does not appear that any section of the Alarm Contracting Licensing Law of 1991 is being violated, but to pass this information on to the Tennessee Attorney General's office.
Heard with counsel.
Second.
Motion by Mr. Harvey, a second by Mr. Cockcroft to concur with their counsel's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Chairman, that concludes the legal report, and I appreciate y'all's thoughtful attention very much.
Thank you for the report.
On that last matter, I didn't think that we, as a board, were concerned with I mean, I thought that was a tax matter as far as whether they
Oh,
send
Why we
money or not.
closed it.
We don't ever,
Our
it's,
concern was that if they were true independent contractors, that they weren't being tracked. They weren't being put on the employee list, but we weren't making them get registered as a contractor. So our concern was these folks are going to fall between the cracks, and nobody's ever going to follow them.
But they are registered, it's just the way in which they're being paid, more or less, is
Paid.
how.
And so I don't think it's a violation of our act, which we're required to enforce. And so I don't think that's something that the board really needs to go into, but it may be something that some other folks are interested in.
We're going to be in recess for approximately 20 minutes. Thank you.
After the appearances, and then we'll take up with Exhibit B. The administrative report's fairly short and sweet. Have 10 applicant reviews for later today, so if y'all don't mind, we'll go to Exhibit E. Exhibit E is a request for a second 90-day extension for a company to replace as extenuating circumstances in the previous qualifying agent deceased. Actually, both of the parents who were running the company are deceased.
Make a motion, we grant a second extension.
second.
Okay, we have a motion by Mr. Harvey and a second by Mr. Cockcroft to grant this second extension for a qualifying agent. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Okay, the next item is Exhibit F. We have a qualifying agent applicant who's here to discuss his experience. Mr. Bryan, if you would have. This is actually the applicant for the same company. There's several documents here. He's been employed at the company since May of 2007. However, they neglected to register. I have several documents in here from customers, coworkers, a copy of his 2007 tax return information showing that, he did work there. There's really very little other documentation that he could submit to prove that he's had this experience. I would review those in Exhibit F.
All we're lacking is the time frame experience.
Got his training in Berg and CCTV. He's already submitted the application in November. He's here in case you have any questions for him. And based on the fact that this is a recent, we have not set up a complaint against the company for failure to register him. qualifying agent, other than whatever y'all determined to do to the company itself, there's nobody that was responsible at the time.
When did,
Taking over the family business.
when did your QA leave?
My father passed away in July of this year, ma'am.
But he never registered you?
Aye.
I wouldn't be able to state for certain for that. Only he would be able to do that, but I can. This is a family business. I came on in 2007. His health was beginning to decline. His wife, my mother, who was also heavily involved with the she was diagnosed with cancer in 2008, and I'm not sure as to why he never got the proper paperwork filed.
I just
That was-
asked, but it was just because of your application, your license number, his license number. It looks to me as if he's had his license back in the beginning.
Yes, ma'am. He was, from what he told me, from my understanding, he was grandfathered in with his license. And it was in the beginning when I first started working for the company, he did order a packet to start the process, and why that was not continued, I don't know.
Are other employees with the company?
There is another employee that is certified. Tommy Saunier has been with the company for close to 20 years now.
Main reason for the appearance is it has to do with the experience for the
Because he has
Was
never
never
been
registered.
registered and all we have is correspondence, I told him he might want to be here because I thought you might have.
Most have 5 years of experience, registered experience.
Actually, it just says involving the actual installation of alarms. So he's got correspondence to document that. We have not established a based on your determination today, we may.
So
How
it
long have you
doesn't
been-
say you have to be registered for 5 years before you.
You have to have 5 years' experience involving the actual installation of alarms. Based on the fact that he's never been registered, we have proof that we would accept from an out-of-state applicant. Because of the circumstances, I felt that y'all would be more comfortable reviewing his, if he was here so he could answer questions.
How long have you been involved in the business, or?
Since 2007, sir, in May of 2007.
Done installation and sales and a little bit of everything, or?
A little bit of everything, yes, sir. Under the guidance of my father for as long as he was able to physically, and as well as working alongside Tommy Saunier.
Work full time? Were you there, or?
Yes, sir.
I would make a motion to, we need to accept his experience for the, into a, so the application, or? Okay.
I want to also note, he had his level 1 certification training in 2008, and he took the CCTV training.
There's one letter here. You say you've been there since 2007.
Yes, ma'am.
My husband and I have been customers of Security Electronics since 2003, at which time we came to.
And that particular customer is a member of our church, and that's how they came to know me initially, was through our church.
Back there. That's what I'm concerned with.
Okay, we have a motion and a second to accept his experience for his qualifying agent. All in favor, voice by saying aye.
Aye.
All opposed? I oppose.
Why would y'all oppose the experience? I understand.
I cannot, in good judgment, I'm not gonna vote yes.
When everybody else has to prove 5 years
And
and
he's
be
been-
registered.
That's correct. The fact that they never bothered to register him doesn't sit
That part's
well.
wrong, I understand that, but it's obviously he's been involved with the business.
You're
It's-
rewarding good behavior for bad.
But I don't think it's his, and
Registered in '07 when the packet was presented to him.
What do we do, Mr. Scudder, in this?
Going to have to make a determination today. The statute requires that the application has to be satisfactory to the board, and I don't believe a tie would be construed as satisfactory to the board. So I think determination whether or not you want to decide today or whether you want to defer it until a point later on when there might be an additional board member here. Or if you make a decision today, the decision today would be a no. But I believe y'all would have to vote on whether or not you're going to make a decision today or later.
I was just gonna ask if you would consider establishing a complaint against the company itself for failure to register.
I'm assuming ownership of the company has changed.
To me, sir, yes, sir.
Oh, because it's a corporation, it's not really a new company. That's why we granted the
License
extension.
number, same everything.
License number. He's just now.
No groundwork laid.
You guys aren't recognizing that he even worked since then, so what's the complaint?
Registered experience.
By his own admissions here, he's got years of unregistered activity.
But you can't have
What
it
more do
both
I need?
ways. Either he's
Sure I
No other
can.
way to qualify, Vivian.
He could have been registered
Filled out his
rightfully.
packet.
I'm not arguing that.
I know that.
I'm just telling you,
That's-
I've advised him because he wants to qualify the company to at least.
Have all these years of unlicensed activity that you're wanting me to give him credit for so that he can be a QA when everybody else.
Has to go get a QA and work for him for 5 years or 4 years, excuse me, and then take the test as he's already done, got that under his belt, and then become his own QA, and then fire the QA he had if he wants to. But you've got to go find a QA to run a company that has all that experience.
Would you feel different if he had worked for a company that wasn't?
No.
I mean, if he worked for somebody else that didn't license him?
No,
No, I wouldn't feel it. It's the fact that you've got.
It's not his responsibility to.
it's not his responsibility to want to be a QA.
To have been registered or to be a registered employee. That wasn't his responsibility.
Simply an
We're
employee.
penalizing him for something that.
He said that he didn't work those years.
Yes, it
You were
did.
a full-time employee since 2007 for the company, correct?
I was a paid full-time employee. I was under, as far as my work in the field, I was always alongside Tommy Saunier or my dad early in 2007, 2008 when he was physically able to take me out for training. Other than that, I was in the office and did a little bit of everything.
But that's just my opinion. So what
I'm
is the man
supposing
do?
I voted my way. I'm gonna have to say this, because in '90, when my father owned his business, the thought come across his mind: what if I die? What's gonna happen to my wife? And the thought crossed your father's mind too, or he wouldn't have give you that packet. But you never followed through, and then and I'm in that position now, that shape. It's a shape. Any way you look at it, your parents get old, something happens, and there you are. You got a lot on you, not just the company. I understand that, and I'm not discriminating against you as just personal. It's just you did start, you just didn't follow through.
It wasn't for him to follow through.
Yes, it was. Sign this, Dad. I've got to send it in. You're done. That's
Okay,
what I told
Mr.
mine.
Scudder says we have two choices. The vote stands right now as a tie that no, we're not going to approve it. Or if someone wishes to make a motion to table it until
To table
March.
it till Ken's here.
In March when we have hopefully 5 board members here.
And we've already granted an extension.
That's correct.
Right, so.
That's
No,
gonna
even though
run
I
out.
voted no, I have no opposition to waiting until Ken's here and giving you a fair shot.
I have no doubt about your
With
qualifications
odd
whatsoever.
numbers.
It's just, and if it was a couple of years or so, I think it's the time frame and it being a family business and you being so intricately involved in all of it, and you're working beside a registered employee. Those are the things that I have real heartburn over. Why you never did it, I don't know. It's not for me. It's just based on the proof we have here in good conscience. I'm not gonna vote for it.
I can't understand why he registered the other fellow but not you. What were you pursuing, really, instead of the alarm business?
You have a criminal history?
No, ma'am. I went to college initially, graduated with an associate's degree from Walter State, with a degree in stage management, and worked several jobs for the Louise Mandrell Theater and Wonder Works in that nature, as a stage manager, and
Entertainment.
yes,
you,
ma'am.
You really
Uh,
didn't want to be in the security business. It just happened that way.
Well, I've been around it all my life, ma'am,
Yeah.
since I was little. And initially, I didn't, and then once me and my father talked, and he wanted me to come on and help out, and train to become a alarm installation technician, and I'm sure that he had in his mind one day for me to be the QA.
But he knew
But
that
he
you
never-
had to have some time. You know, like a life estate, he knew that it had to be in place for so long before he was going to kick in.
I have to
What
assume.
the board we need to vote on bringing this back before the full board
Yeah,
at
just
the next
table it.
meeting. Do we have a motion?
I'll make a motion that we table it until our other board members here, and there's an odd number, and he has another chance.
Do we have a second?
Second.
We have second by Mr. Harvey and Mr. Cockcroft. All in favor, voice by saying aye. Aye. All opposed? The motion to table the matter until March has passed.
So, I have one question. You granted them a 90-day extension. Okay,
That
well,
was
they
before we
requested
knew
that
this.
on November the 4th because their previous extension expired.
Can we revisit that?
Can you go back and look at that and at least extend them so they can continue to operate the business until?
I would say that's our fault, not his.
Well, we
Yeah,
kind
we
of
don't
got the
have a
cart
meeting.
before the horse on this, on granting an extension and not knowing the circumstances for why they don't have one also.
I got one other question, if I may.
Yes, ma'am,
You're
Secretary.
going to be the CCTV and Berg QA, or that's what you want to be. And who's going to be your fire QA?
We will. I will no longer be
Need that person.
involved in fire installation.
Okay.
Um,
Any other company would just have to suck it up and keep that person on the payroll for 4 more years, and then you'd have your 4 years experience, and then you wouldn't need it. If he can do fire, he can pass a Berg exam. Because I'm telling you, the fire, I did it. It's harder. So,
Pass the exams. I hear.
Always have
I
a training.
haven't-
He hadn't scheduled the exam.
I haven't
yet.
scheduled an exam for the
Oh.
burglar or the CCTV.
no, your other, this Tommy, is
Tommy
Tommy the
Saunier.
fire? Yeah.
My father was the designated QA for the Berg CCTV and fire heat and monitoring as well. At one point, we had we monitored some alarm systems. That was what his license covered.
Is Tommy a QA?
Tommy is not a QA. He's
Oh.
a registered employee.
You have access to a QA that you used to have other than your father?
No, ma'am.
I'm trying to help him get his license to where we can just go ahead and pass it today and say, yeah, instead of having him wait till March. I'm trying to give him a fair shot. Me personally, I'm going to say no, so it's up to the rest of you. No, I'm for extending it. Because if,
Oh,
I don't know, we've already voted on both of them. Now what do we do?
well, you voted to grant them a 90-day
kind of-
extension.
About it
I
backwards.
think you could take another motion valid until the next board meeting.
And I feel like if I'm gonna wait till then and change my mind, then I shouldn't do that either. I should pick a direction and stay with it. So that's what I'm
Our
gonna
other
do.
option is to establish a complaint against the company itself for failure to register an employee. That with their response on why he wasn't registered.
I don't know.
Much of a
I-
In the
choice.
past, you have approved employees who weren't registered, as long as whatever penalty was assessed against the company was paid prior to him getting approved. That has been done more than once in the
That's
past.
not what, I don't think that's what these two board members are talking about. I think we're talking about the knowledge of knowing that you had to have a QA and your health was declining and you called your son in for help and you didn't do anything about it.
Karen, we can't second guess that. We have
No, he didn't do it.
don't know what health problems he was experiencing at the time. We don't know any of that. Question today is, number one, can you approve his experience? And you have not. Long enough that they can continue to operate until our next board meeting.
I'll make that
I'm-
motion.
That was not gonna be the motion I made, but that's okay.
Do we have a second?
Second.
We have a motion and a second to grant the extension until the next board meeting, which at this time appears to be March of 2015.
Is there a limit on when we can extend those or how many extensions there can be?
Law says that the board can grant a 90-day extension. What's happened in the past administratively is that the first extension is generally approved by the director. Any subsequent extensions, second or third, are brought to the board for approval.
The main reason I was asking was just so that he might be prepared, because you might need to look into other, depending on the outcome of that, but we could possibly grant another extension if he wasn't.
Another one at that time.
Okay.
And now we've
But you
got-
still might want to look into other options just based
And then
on,
you're also gonna have to address what if we're missing a board member at that time and everybody. Right now, we've got an open motion to grant an extension to let the company continue to do business until.
We have a motion, but we don't have a second, I don't believe.
I seconded
Oh,
it.
did you second it? So it's up for vote. And this would be granting them technically their second extension because they've already had one administrative extension, correct?
Right.
So
just
this is,
extending the one we already have, right?
Yeah, they
We
brought-
gave them a
this is
second.
the
Granted them
board's
one.
first one, but
Oh,
it's
okay.
technically the second one.
Okay.
Second extension. Never mind, I was gonna repeat what you said.
Okay. We have a motion and a second to grant the extension until the next board meeting. All in favor, voice by saying aye. Aye. All opposed?
Opposed?
The motion carries for him to, for us to grant the extension until March or the next board meeting. Now, what do we need to do for the unregistered activity, unregistered employee activity?
Thanks for coming in. Sorry about your parents.
Is there any possibility you can find a QA for your business?
People do it all the time.
Just, is there a
Yeah,
place I
on
could go look?
Website,
Okay. I will
state
definitely
website.
pursue that. I apologize, I'm ignorant about a lot of this.
Well, I don't know. I think all of the laws and rules are on the internet. Is that correct? Where you could review them. Even outside of this area, you are operating within the laws and rules, so you won't have any more problems. Thank you.
I wish you the best.
Okay. All right, now we're gonna move to Exhibit G, which is Mr. Travis Brown. when you look at your Exhibit G, Mr. Brown's application was denied by the board on September 18th. We received an appeal to that denial on October the 1st.
I think, were you on probation at the time when you submitted your which introduce yourself
That's
to the
me.
board,
I'm
please?
Travis Brown.
And next,
This is Craig.
Craig Miller.
And
I'm
you
the
are?
QA.
okay,
I'm Dave Jarnigan. I'm our general manager.
okay. I may be mistaken, but I think at the time when we had this application come before us, he was on probation for some type of domestic incident. Is that correct? Are you still on probation?
And I'm pending the payoff of the fines.
Days apart or what?
I remember this. Y'all are Smyrna? Is that, okay. Yeah, I think I remember this one. That's correct, because he was on probation for domestic assault at the time.
Won't change until February, I guess, will it?
It's around that.
That's what I was going to ask you. The conditions of your probation at this time is what?
Just to pay them the court costs.
Did you have to complete like any type of anger management or counseling?
8 hours later.
And you passed that? So you're telling us the only two things that's keeping you on probation is 2 payments to the court?
That's right, $400.
And you're not behind on these? Okay. How many, you've got in here 26 anger management classes?
Yeah, that was separate.
Isn't that the one you're on probation for, though? Is the incident that her sister witnessed, or is there another?
That was separate.
Okay, when was your second one then?
It was almost a year after, and
Okay, you've got on 8/10 of 2013, so are you saying again this year you were arrested for domestic assault?
it was within a year.
No, but we don't have this 2000, we don't have a 2014 incident in our packet is what I'm going on. We have a 2013 incident that you received 11 months, 29 days, unsupervised probation, 26 anger management classes, and you're currently on probation. When this came before us in September, I believe it was, you were still on probation for this incident, but now you're telling us about yet another domestic violence?
Can I clear this up?
Certainly, please.
The incident in 2013 is the actual probation I had to serve. It was 26 anger management classes, and that is off of that probation. But there is a retired case that happened the second. I was not a primary aggressor. My wife just became angry.
About the 2006 incident?
There's a 2014 that we have no paperwork
I don't
on.
have anything on the
Nothing on that.
2014 incident at all.
Well, that was in Murfreesboro.
And we got your, got 2006 that you disclosed, 2010 public intoxication, 2011 public intox and domestic assault that was retired, and a 2013 aggravated assault dropped to domestic assault. We got your application actually in November of 2013, but I don't have anything in here about the 2014.
They just haven't sent anything.
That's correct. The last thing we have is August the 10th of 2013, and that is the one, according to his statement, that was he and his wife and his sister-in-law. There's a statement about it, but we have nothing about any subsequent incident between on domestic. Had other arrests besides that?
Want to tell us about that? You started.
Yeah. So, I mean, we were basically at a company Christmas party, and she had went up to the room and bottom little restaurant there, and she just came down, and it started having heated conversation and whatnot, and they called the police, and the police obviously took both of them in. She was the aggressor, but they said because it was in public, they were going to take them both in. We thought we had it squashed to where they weren't going to take anybody in, so I don't know how far they went with sending anybody any kind of paperwork with that. It looked like it was just swept under the rug for the most part, other than paying some fines and that kind of thing.
Charges or something on that one, or maybe it's why we don't. But I guess that was also.
The background check we have was done in October of 20. He actually got his
Before the
prints
incident.
done October 17,
I don't know anything about
2013,
police
so
reports.
it's not on here.
So I have to ask her.
Oh, I was asking her, since I'm supposed to have it on record, she is our public member and retired police, whatever, and I have to ask her what these forms are. Help me, in 2006, October the 26th, how'd you get that felony?
It was charged as a felony in the beginning. I was actually at my residence. Guys that I considered friends at the time came by and
Live where? Okay.
they proceeded to drive down Blue Hole Road.
Have to lean over into the mic, please.
Sure.
It's still not picking up.
Not picking up?
Yeah, there you go.
Okay.
When the red light's on, you're okay.
Okay, so I apologize for that. I was
You do have a letter of explanation in here regarding that.
Yes, ma'am.
Indicted?
Was it,
Written right after the.
do you have a help me, what am I asking? Management?
I have an opportunity to expunge this. I just have not been able to pay the cost to have it expunged. $300.
Really?
Y'all have any questions?
But it would clean your record up, and then you would get your fines paid, and you'd be off.
But ever since, I've just really been trying to keep my life on track.
Kids do you have?
4-year-old son.
If I could say anything to our experience with Travis, and Craig can back me up on this, we brought him in just as a greenhorn. Those of you who are familiar with our business, we've got kind of a residential new construction business where we do a lot of low voltage, audio, video, that kind of stuff. We started him just training with other techs there, and one of the first things we noticed was he just had some really good leadership qualities. He started rising to cream of the crop. Before too long, he's our go-to guy. He's getting our jobs done the fastest. He's training our new guys to come in, work for us for almost a year, to a point where, I mean, we really depend on this guy. I mean, if guys come in and the jobs are really sucking for the day, he's the guy that's going to rally them up, say, come on, guys, let's go do this. Let's get it done. When I look at his record, and I know it looks bad to see those things, but that's not what we see in this guy. That's not what we see on a daily basis. I mean, it's a positive attitude. The guy's contrite when he comes in. So I mean, it'd be a shame and a loss for us to not be able to have him rise up. I mean, we can keep him doing audio, video, and stuff like that, but his potential is so much more, and we'd like to see him get past this part of his life and be a more positive contribution to our company.
Though he was denied by the board, and there is an incident we weren't.
These things ain't working good.
You have to really speak into the microphone.
Is it after he's off probation, since that's what we denied him for to begin with?
Denied him because he was currently on probation
Right.
and there had been prior incidents, but again, with this new incident that we have, back to work if he reapplies until we could hear it again. And
I think we have a hard time approving with probation still there. I mean, I'd really like to approve you, but I think the probation, even if it's a financial, hard for us.
Any difference if
Leave him alone.
I mean, I can go pay the probation today. He's worth that to me. So, I mean, if that's what you need,
I walked in here with that, it might be a
hey,
different
wouldn't have been a
story.
good idea. I should have done that.
Because,
Right?
I mean, we've kind of been hit blindsided. I understand he submitted his application well over a year ago. But then, you know, since he submitted it, he's had another domestic incident for which he's still on probation. And there's a pattern of activity here that has repeated itself about 5 times, and 4 times if I count correctly. And you're right, he's still, and the boards, normally, we just don't grant employee registration to somebody who is on probation for a criminal offense.
I totally understand that. And actually, I wasn't aware that was what exactly he got denied for, or else I would have taken care of that.
He was
And-
on probation for the 2013 incident, plus one we didn't even know about.
That one has
Well, after
since
it's
ended.
expunged.
And the one that I'm on now, the way it was explained to me is that it is a retired case. The only reason I have to make the visits is to pay the fines, and the court costs.
That's the one that I was witness to and was absolutely shocked that he came away with any kind of charges for that. Like I said, I wouldn't, yeah, I mean, I was there, I saw the entire thing. So, if it's a matter of getting that taken care of, I mean, I can take care of that today, but
I don't know
Well-
if we can do a provisional. Can we do a provisional?
Correct me, guys, and I know you will if I'm wrong,
Huh?
but don't we usually have to have an expungement also for a felony?
It was reduced.
I think what would be
Okay.
a cleaner solution for all of us, I think if we could ask you to reapply charges in our file, and we know exactly what we're dealing with. That would allow you to continue working until you could come back. By you come back at our next board meeting, all your fines will be paid, all your time will be up. We can cleanly say, go for it. You know, I think that would be my opinion. I think that's just a cleaner solution for everybody.
I agree.
He'll still have a job doing other stuff, won't he?
yeah, it's
Just not
the-
alarm work.
You know, this time of year, the builder industry slows down a little bit. So, we've got huge commercial projects going on that I can't let them touch right now. So it would affect them. So the solution that you guys are offering would be generous, and we'd appreciate
Audio,
it.
video should pick up though, and theater stuff like that.
But he can work in the, I mean,
Right, if he
He can
reapplies, then y'all
continue.
let us change him back to an applicant from denied crim, which it sounds like that would
30
happen if he
days.
reapplies, then he can work until you make a determination.
Right.
work in the alarm.
Right.
So he can do whatever it is you need him to do. So I would make a motion in that regards, that we just ask him to reapply.
After anything, or just reapply now?
Just reapply.
I'll second.
Okay, we have a motion and a second to have you reapply as a registered employee. All in favor, voice by saying aye.
Aye.
Aye. All opposed? Thank you.
Thanks for coming in. It helps.
Next item is Exhibit H. Mr. Leverett. What happened with
So that's not it.
There's another fine. If you don't have it in your termination notice. We're trying to help them.
Okay, well, we don't have an Exhibit H.
Okay. Which one's next?
Exhibit I, Mr. Turnbull.
Bill, are you okay?
The board requested this appearance after you reviewed his application in September. It's Exhibit I. Mr. Turnbull and his designated qualifying agent, Mr. Hancock, are here from ADT in Knoxville.
Got things while I'm reading. Will you tell me the general basis of what it was we asked him to appear?
Well, again, when you reviewed it in September, he has disclosed a 1995 theft charge, a 96 simple possession
Yeah.
charge, 97 domestic assault charge. Now, I don't know the dispos on all these. I'm just looking at the charges he disclosed.
04.
97 bad check, 99 domestic assault, 2004 possession of Schedule 2, 2004 possession of Schedule 4, I believe, and paraphernalia. There's another simple assault charge in 2013, and there are several charges for driving on a suspended license.
What were your possession charges? What were your possession charges? What did you possess? You have a 2013 assault charge.
Yes, ma'am.
What happened with that?
I was asked to do anger management and completed.
They dismissed it, you said?
The incident surrounding
What
that.
happened?
Well, what had happened, basically, my stepdaughter mouthed off, and I flew off the handle more than I should have and smacked her, and my father had charges pressed against me.
That's the 2013. That's the most recent.
What happened in 99? Or is that what you're talking about? Your stepdaughter?
No, that was
2013 for when it concerned my stepdaughter.
What was 99 about? 96, both assault.
That was my ex-wife. She was a vindictive woman and a promiscuous one at that. Basically found her cheating on me a couple times, and I always was the one that wanted to walk away, and she was the one that always wanted me to stay. And she would hit me and smack and kick, and even when I try to get away, you know, she would make herself look like she was the victim. Sometimes she would rip her own hair out and scratch herself and tell the cops that I did it. And everyone in Clinton that knows me knows that I'm not that natured person. Any assault charge I've ever gotten was either from just me not taking a moment and breathing and counting to 10 like I've been told to do in counseling before. Even in my attempts to get away from her, I still wound up getting charged, but even all those have been dismissed as well. So
What's happened since then? What's your aha moment?
I got my associate's degree, just graduated this past 2014. I decided I wanted to do something with my life, and there was a hindrance in the incident in September of 2013 with my stepdaughter, and I honestly didn't expect it to go down the way that it did, but that's just the way things go. But I showed up to court and I presented my case, and they were going to drop it to simple assault, and I told them that no, I wasn't guilty of that either, and then they went down to bounding it over to the grand jury, and then they decided to just give me anger management, and then I completed that. Yes, ma'am. Everything's been fixed. We're making it work. It's
Mr.
difficult.
Hancock, how long has Mr. Turnbull worked for you?
Mr. Turnbull came in, and he worked approximately 30 days until we got the application sent off. And after the application came in, we put him on an unpaid admin leave until the outcome of the board.
What's your recommendation?
I personally can't give a recommendation on Mr. Turnbull, not knowing him, other than when we filled out the paperwork together.
Do for some time, or is it your business?
No, I've been the QA for,
It's ADTIC, I'm sorry.
yeah, 4 to 5 years. I'm thinking how long I've been the DQA there.
I think Mr.
So
Harvey
you-
asked you that because it jeopardizes your license if you just step up and say, hey, yeah, I'd like for him to work for us.
Yes.
Oh, So you worked for 30 days with ADT until it was turned down, and then but he did work for 30 days.
I don't know if he actually got 30 days in. As soon as we got the application completed, and I never, that was probably the lengthiest application I'd ever sent in, and it did just raise a concern, and that's when we did the unpaid admin leave until we sent it before the board for the decision.
Are you the manager of that office as well as the QA?
Not of the division that he's in.
Yeah.
The way the office is set up, he has applied and he was currently going as a small business sales representative. Sorry about that.
I think that was part of the reason we asked. I can tell you that as a general rule with a record this extensive, it typically is just a no. And I ask you to come in kind of looking for some more things to work with here. But,
Because we have no recommendation on his work quality or work ethic from the company.
Right, and with
We
him,
kind of have y'all, and then we have him, you know.
right, with him not being there any longer than he has been, and me not personally knowing him, I could not do that.
What does personnel suggest you do?
I'm sorry, can you repeat that?
What does personnel suggest you do?
Personnel suggests that I send food.
Without any input?
Correct.
Do you have all your driver's license and insurance and all that in order?
Do you, Mr. Turnbull, understand why we're asking that?
Let Mr. Hancock.
Okay. I want
Mr. Hancock.
Okay. When it came up, I know there was the opportunity to write a letter of recommendation, but when we looked at that, we chose that since we didn't do that for any other employees in the past, that we wouldn't write a recommendation for this one as well.
I was basically training. I was watching videos for the company and getting an idea of, the dashboard and what I'd be working with. When I say dashboard, I mean going in and, counting off knocks in a certain turf area. Actually had previous experience with True Green recently as a small or residential salesman, and had similar concepts going on with that. I mean, I did that for
No, it was
salesman for
Never
about
mind.
6 weeks.
Never mind.
sales, but
Go ahead.
Bill, I don't know what the board will decide here today, but we run into this from time to time. Sometimes our past catches up with us, and the history doesn't do us justice. But sometimes there's just certain industries that doesn't accept a particular type of past, and unfortunately, this is one of them. And I can say from my perspective, that's why we asked you to come today. Is we just want to kind of talk to you directly about your past. What is going on with you today? What's happening in your life right now?
Well, been taking a little break naturally, and it got to be a little long. Needed some money, so I applied other places. Like I said, I worked for True Green for a little while. Had problems with the payroll there. They shorted my check twice. That was a little unnerving when you have 6 kids. You know, you need every dime that you're getting. Other than that, I did resign from there and told them that I was going to continue the search for something that was more in my, field of interest and expertise. My father once had a home security, well, a small company. He called it ARC Security, and ARC was an acronym for Anderson, Roane, and Knox. He only serviced those counties. So, I mean, not only just from the salesmanship point of view of the company or a company, I, have a little bit of experience with how things work with alarms and security, things of that nature. So other than that, just enjoying the holidays. My mother recently had surgery, and I've been helping her. It's another reason why I took off. My wife's car recently has presented some problems, and we've put it down for now momentarily, and she's been using my vehicle a lot for her job. She's a sales rep for Comcast, and she has insurance with the company, and it actually kind of got pinched out of the position I was in with True Green, because not only was, things weren't working out, corporately, things weren't working out at home either as well. Picking up children from school and things of that nature, it conflicted with the schedules.
6 kids, not just the one girl.
My daughter Victoria is mine primarily, and I have 2 older boys that no longer live with us.
There's a company. As
Questions for either of these gentlemen? Does the board have a recommendation on his status?
I think that because of the length of the record and some of the newness of some of the charges there, I think I would have a problem changing our initial vote on this. Maybe with
Okay, we have a motion by Mr. Harvey for denial. Do we have a second?
sorry, I truly am, but I'm going to have to second that. Our job is to protect the public, not, who you're working with. And we have to worry about salespeople, technicians, etc., going into their houses and being confronted with rather hard situations. And you just got to hold it together.
We have a motion by Mr. Harvey, a second by Ms. Jones to deny this employee registration. All in favor, voice by saying aye. Aye. All opposed? It's denied. Thank you for coming, though. Okay, next on the agenda is Mr. Nicholas Williams. Is Mr. Williams here?
Try to speak into the microphones, okay? I think they're not functioning very well, but
They're not
I
very...
can just slide it right in front of you. It's kind of over at an angle. Look, there we go.
Well, you each have one, so you can put yours, and he can... There you go.
Is that all right?
I just put it on speak instead of mute. I don't
Will
know
it
if the
stay going?
volume thing's really...
Got the master.
I've got... This is the master right here. I'm trying to see.
No, yours is. Look, it's different than everybody else's.
Mr. Williams' application was also presented at the September 18th board meeting, where the board requested that he appear with his designated qualifying agent for international systems. Mr. Bruce Marshall is here with Mr. Williams today.
Thank you for coming. We'll need a few minutes to review your file, okay?
Ma'am.
Mr. Williams only had one incident that was disclosed, but it was recent. It occurred May 19th, 2013. Yep. Yes, ma'am.
Say that this was the only one that was disclosed.
Yes, ma'am, but due to the recentness and the
Correct.
nature of the charge, you guys requested that he appear.
Really wanted to hear kind of from you what transpired with that event. It seemed like it was a little, and I don't know, maybe the fact that it was on a base or something, but just kind of what happened. I don't,
Well-
I don't know if y'all ready.
Yeah,
but-
just explain to us what happened.
That day, I'd gone into the PX with a few friends. PX is basically a Walmart proposed. And at the time, I was taking some medication for my back. And I just remember, having the bottle, looking at it, and then I remember being outside with everyone and then being stopped by the security there at the store. And we discussed it, and I told them, I didn't try to lie to them or anything. They said, all right, well, because this even happened, we're going to still have to call the police. They called the police. I was brought over to the MP station and was dealt with from there. I went to court and immediately that week paid all my fines. And
Where was
got
the bottle of cologne when they confronted you?
It was on my person.
Where was it?
Where,
Where was
oh,
it?
in my pocket.
So you didn't walk out absentmindedly with it in your hand. You secreted it somewhere on your body and walked out of the PX.
It was absent-minded, but I
Didn't put it in a buggy. You put it in your pocket or a basket. That's what she's asking.
Started that statement with you were on medicine for your back. What kind of medicine were you on?
Percocets.
Okay.
I had sustained a back injury during training in Fort Carson.
Dosage?
Yes.
Do they still have you on them?
No. When I was in the military, I was on it, but after that whole incident and seeing what it did with, me mentally, I decided I did not want to take any sort of medication anymore.
They're not treating it with any kind of. Did it smell good?
Yeah.
What was it?
Dolce Gabbana.
Oh.
Since then, I've bought plenty of cologne.
He uses Aqua Velvet now instead of.
It's more in his price range, correct?
Mine as well.
That was a pretty expensive bottle of cologne.
Actually, it was only listed as $38.40.
Yeah, but I think the fines were $2.75. That's what I'm saying. That's a pretty expensive bottle of cologne
in the long
to start
run,
out so
it
cheap.
was.
Most expensive bottle of cologne I'll ever buy.
Is the one charge was the other, or is the other, because on some of the paperwork it shows is theft of government property what it was considered because it was on the base, or is that?
Correct.
So but
Yeah.
it's one incident there.
But you have no other criminal incidents?
No, ma'am.
No DUIs, no anything in your past
No, ma'am.
except this one?
You were in the service there on that's where you lived, on the base there.
So once you paid your fines and took care of the court's demands, what is your status?
That was the last I heard of it. I had the court never contacted me again. No one told me anything.
Discharged?
No.
So you're still in the military?
Oh no, I'm out of the military now. I served my contract and I'm out.
What was your discharge status?
General under honorable conditions.
Mr. Marshall, correct?
Yes, ma'am.
How long have you known him, Mr. Marshall?
Well, I first met him prior to his discharge, and through some friends. And so we had actually several interviews. And he was telling me at the time that he was about to be discharged from the service. And as a veteran and a retired military man myself, I was interested in seeing if I could help this young fellow get a job. He was looking for employment and such. At that time, we spoke about all of this instance that occurred, and I think the initial application was turned down because we didn't get all the paperwork in time. So that came back to me, and we immediately reapplied. And we're still under an application status, I believe,
But
now.
he is still working with
Yes,
you
ma'am.
pending this
I
outcome?
kept him on during this process. I got to know Nick fairly well. He worked out of my office and then now is working out of our Vanderbilt office. Fire alarm testing for us. And in my review of all of the paperwork that the Army came down, I got to the impression that they kind of threw the book at him to make an example of him. I thought hard on him, considering the amount and what transpired. But in my conversations with Nick and getting to know him and to see him how he interacted with our customers and other people, I didn't find that this was a real detriment to his character. I think he's quite a fine young man. He's recently married now, and I really would like to keep him on with the company. I'd like to keep him employed with us. So,
Well, I think when the board sees a theft of property from someone, we have to take a second look at that, because
certainly I understand that.
if you're going to have him entering in customers' homes, is there going to be a temptation to take some of that customer's property? You know, that's our concern. If he would take property of someone else before, is that a possibility? And you're willing to take that risk with him, is that correct?
Yes, ma'am, I am. I would think that that's not a risk with him at this point.
Own the company, or you the QA,
I
or
am
both?
the designated qualifying agent. I'm not an owner of the company. I represent our Tennessee brand.
Worked for ISA.
Questions for either Mr. Marshall or Mr. Williams? Have a recommendation?
In light of what we've heard here today, I'd make a recommendation, a motion that we grant Mr. Williams his registration.
We have a
Second.
motion by Mr. Harvey, a second by Mr. Cockcroft to grant Mr. Williams his employee registration. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Congratulations.
Good luck.
Thank you very
for
much.
coming forward.
Ready to report? Do we want to take like a 5-minute break or move through?
Is there any, are you an appearance, sir? Oh. I'm Miss Jones. What's your name?
True
Truelove.
Mr. Truelove before.
He's been in the audience before.
He had to come in and y'all approved his experience.
I remember seeing him. I told Vivian I remembered your face, but I didn't know if you was here for the appearance.
We're going to be in recess for approximately 15 minutes. Order this December the 11th, 2014, member of the Tennessee Alarm Systems Contractors Board meeting. Are we going to go to the administrative reports or, okay, administrative reports.
Okay, we're gonna go to Exhibit B, the open complaint report, and I don't have it up on the screen. Before today's meeting, we had 61 open complaints. We heard 31 today. So that should bring us down to 30 or under, in case there were 2 respondents in some of those. I didn't see any that had 2 respondents. So that puts us in really good shape. Move into Exhibit C, which I will put up on the screen. I can get it up. October, and in the month of October, we had 2 fines, 2 civil penalties paid. A total of $400 was paid in civil penalties in October. If you notice, we did have quite a few in private protective services. So student loan suspensions were all for private protective services this time. And then when you looks like we have a total of $5,200. These are fair to submit the terminations and unlicensed activity. We did get one paid for the misconduct from Guardian when that was for allowing their salespeople to approach consumers and, you know, that type of stuff. Private protective services had quite a bit again, and the are all for private protective services. Does anybody have any questions about? I usually send all these out. I think I've sent them out to board members. I don't believe I sent you the monthly report yet. I just did it yesterday. Item on your agenda. Monthly reports, and a notice again, we have stopped putting the figures in there for how many were apps received and how many apps were denied, because the information we were getting from administration, I believe the way they were running their reports, the number of applications was incorrect. I can go back if you would like and run a report every month and let you know how many we've denied material misstatement and how many were denied crim. But for October, the only issue is that Vivian's term expires the end of this year. They haven't made an appointment yet. And November is gonna be the same thing. And I may have it's at the very back. Keep going. We had a private protective services hearing yesterday morning, and I got a little delayed in getting all this done. Our complaints opened in November. We opened 6, we closed 3, and we had 12 at that time that were open more than 180 days. I believe we addressed all 12 of those today. There may be still one dangling that we don't have enough information. That has been significantly reduced today after the meeting. Cody and Mr. Scudder attended the International Association of Security and Investigative Regulators conference in Lexington, Kentucky in November. And I believe, Ed, did y'all learn a whole lot while you were there about
We did.
regulating and
We learned a lot of things. One of the things A lot of people that I ran into were very complimentary of Cody and her staff, how they would say, you know, some places you call, you can't ever get anybody on the phone, but that when you call Tennessee, you could always get somebody just like that. And I was amazed at how much further we are as far as the training that we require. We require a whole lot more training than most states do, and a whole lot more regulatory things in place like ID badges. A lot of states do not require a photo on their ID badge, and you know, it's just the people that were registered there said it's just practically worthless. So Tennessee is really in the forefront. I was, like, on the number of hours that we required, I would have thought that other states were requiring a lot more than we do on our armed guards and that type thing. But apparently, Tennessee is at the forefront in all the areas of private protective services. And we really learned a lot about internet safety. Apparently, that's the big thing in the future is guaranteeing the security of information that's flying through the air in cell phones and pads and that type of thing. That's we had an FBI man come in and explain how they've kind of shifted their focus from, or haven't shifted it, but they used to be the big thing was domestic terrorism, and now they seem to be moving over to cyber security because there are so many complaints and so much damage can be done to people's credit and that type of thing. But we really appreciate the opportunity to go there.
Okay. The next item, I do not have exhibits for either of these. We have we already dealt with Exhibit E. The legislative update, there was no legislation this year, so there's really nothing to update you guys on. On the budget update, there will be a representative from the Commissioner's Assistant Deputy Commissioner, office, who will be attending your meeting at the first meeting in 2015. How they do the cost backs and how the board's doing economically. I don't have any changes in any budget information since the last time Cody. That's one of the requirements we have to have on the agenda at every meeting. Moving forward, we are ready for Exhibit K1. This is an alarm employee applicant. Ballard, file number 32449.
Thank you. Bye-bye.
Okay, Ballard disclosed 1997 DUI and possession conviction in Shelby County, public intoxication in 2010, a DUI amended to reckless endangerment, and then another DUI in 2014. The possession charge at that time was dismissed. And in 2014, he had a forgery charge. He was found guilty and was put on 2 years probation.
Typically, we haven't approved anybody on probation, have we?
Typically, you have
anything.
not, but I don't have the authority to deny these up front. I really prefer you guys review them. Cody has the authority to deny people based on their criminal records. And then generally, they appeal it and have to appear before you anyway. So it's easier for me to let you guys look at it the first time. So I did provide all the criminal history documents. What I generally do is go through these and put these notes in the system so you kind of know what was a conviction and what wasn't, because there's so many documents that they turn in. We do have a letter from the company in support of this applicant. But from the 2014 charge, which is at the back of the exhibit, documents say The arrest date was 5/29/14. The defendant is not eligible to vote or possess a firearm. Final judgment was July the 23rd, and he was given 2 years that was suspended with probation.
Those forgeries are felony convictions.
I'm looking. It does say forgery, conviction, name, and offense, yes. He did provide an explanation, and the QA provided an explanation of what he did. I think the check was in the amount of $65, but it's the way he did it that was the issue. Application date on some of these applications, but we're really addressing these sooner. This application just came in November the. Rhonda in the back are actually helping me call through these so we don't get behind anymore.
Thank you.
So, we'll let y'all review that.
I'll make a motion, we deny this registration.
Based on,
Current criminal history, or poor moral.
We have a motion by Mr. Harvey to deny this employee registration application. Do we have a second?
Second.
And a second by Mr. Cockcroft. All in favor, voice by saying aye. Aye. All opposed?
okay, the next item is Exhibit K2. It's Biggs, file number 32297. Biggs disclosed 2009 simple possession of marijuana, possession of drug paraphernalia, and 3 counts of contributing to the delinquency of a minor. He was fined and given 1 year probation for that. And then 2011, there was a simple possession of marijuana that was dismissed with costs. To provide an explanation. And there is a letter from the qualifying agent who was here earlier today for a guardian. Board approved a policy for us to approve in-house some simple possession charges or maybe simple theft charges if it's been more than 10 years, but this one was more recent.
Write these letters, it kind of sounds like they're not writing them to defend their license. It sounds like they're writing them to say, "Hey, don't worry, this dude ain't gonna do anything to the public." Like they don't realize really it's their license on the line if something happens.
But we asked them to provide a letter of support.
Yeah.
And, you know, apparently they think this guy's okay.
Short one like this, I'm just commenting saying that when they're real short like this and sweet, I don't think they really understand the.
Yeah, the guy doesn't have any kind of theft. He's got 2 possession charges.
Talking not this. I'm not
Not
talking
this
about this
specific.
person. I'm
Well,
talking
some
about
of
in
them
general.
refuse to write them at all, so.
Right. But when they do, they don't act like it's their life on the line.
Well, I don't think a lot of people view it the same way you do, but fairly recent application and this letter came in with it, so.
Told them not to hire nobody that we was afraid that would cause us to lose our license.
Well, and you and I both know, and a lot of times the QA is not the person that hires anybody, and we're holding them responsible for all the paperwork and everything else, so. And for being responsible for supervising the actual installation and quality of alarm installation, so.
Right. That's a scary thing.
All this lengthy stuff is just the payment history. It's not, it's just, it's 2
I don't
charges.
see anything else. I put little
It's what
stars.
all the, like the appearances and how much the different things like the alcohol testing. It's just a breakdown of all the court administrative fines. If you search through it, the main thing is just
These buttons appear on that monitor back there when you push them, like the abstain and stuff. No, I wondered.
They aren't set up, and it would be reflected on the chairman's module if they did.
We're either approving or denying the application. Well, I make a motion to approve.
we have a
Second.
motion from Mr. Cockcroft and a second by Ms. Jones to approve this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
We are ready for Exhibit K3. Blackwell, file number 30267. Have a 2010 theft, shoplifting, 1129 probation, and June 13th, 2012, attempted theft under $500, which also resulted in 1129 probation.
Got a letter from his QA, correct?
He did provide explanations of the circumstances surrounding both of them.
He wasn't driving,
Reckon he has a
was he?
license now, you?
That was a separate charge. He just submitted the dispo for. Already had his license, so.
Make a motion that we grant Mr. Blackwell his employee registration.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockcroft to grant this employee registration application. All in favor, voice by saying aye.
Aye.
Aye. All opposed? The motion carries.
Okay, we'll move to K4, which is Bryson, 32523. Different. In 2004, he was charged with false reports and official misconduct by 2007, the Department of Safety charged him with implied consent. And then he had a probation violation in 2007. I believe that was from the DUI charge, which was implied. The explanation of this is yes.
His explanation for implied consent doesn't wash basis for an implied consent arrest.
They probably charged him with DUI and then reduced it to implied consent because they didn't get, I don't know. I do not have a letter from the QA, and I only had one disposition paper.
Maybe refusal to take the blood test.
Yeah. Or the breath test.
Why would they test him? He was a passenger, you know? They don't blood test.
Yeah.
Well, he would have had to drive the vehicle
'Cause I was
home, and I guess
patrolling.
they weren't gonna let him.
I know, but it would have been PD.
I ain't got that far yet. Y'all must have flipped over there. But anyway, was he driving the car drunk?
I mean, but I've seen them charge DUI on passenger and driver alike. Yeah.
Ben's truck's what I'm saying. You know, he didn't have any liability at all.
PD seems a lot more
Thank you.
fitting.
Well, we weren't there.
Nope.
He is a warehouse manager for Guardian Systems in Smyrna.
Make a motion that we grant Mr. Bryson his employee registration.
Second.
We have a motion and a second to grant Mr. Applicant his employee application registration. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Exhibit K5. This is Green Hall, file number 29082.
Which one is it? K-
Exhibit K5.
Okay.
Closed. A 2002 deceptive practices, 2003 underage drinking, and then a 2006 possession of cannabis and drug paraphernalia.
An explanation? Yes, there is.
Her explanation is here. Court records on most of this available apparently in Illinois. Well, F.E. Moran does a lot of stuff, but we do have a letter from the qual. Deceptive practices explanation is, it almost looks like a juvenile offense, but she wasn't a juvenile anymore. And she is a central station operator for F.E. Moran out of Illinois.
Make a motion to grant Ms. Green Hall her employee registration.
I'll second.
We have a motion by Mr. Harvey, a second by Ms. Jones to grant this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Moving forward to Exhibit K6. Johnson, file number 29664. Mr. Johnson disclosed October 8th, 2014, possession of a controlled substance, heroin, and possession of drug paraphernalia, a syringe. The court documents show that a diversion was requested November the 14th, 2014, and has not been granted yet. There is a letter from his attorney and from his qualifying agent. They're doing is applying for a diversion, but they haven't been granted the diversion. The only charge on his record at all. Stop it.
You can run, but you can't hide.
That's right. Application came in November the 3rd, so it's not been.
You're a new applicant to work in the old industry, right? They're not currently employed. So, I mean, or weren't already a registered employee somewhere else. It is an application to be.
Brand new application that it's not a reapply or anything, it's brand new.
Letter states something about like he's already doing work in the industry or something. Or it
Work
starts
for
at-
30 days before they even submit the application.
It's the DQA
That's
1800.
unlicensed activity.
That's his is there a company number anywhere?
Back here's the
I sent them an email and asked for this letter, and I didn't look at it real good.
I make a motion that we grant.
Not talking into the microphones.
I got two. I make a motion we grant application K6 or registration for a technician or monitoring.
He's a technician with Security Fire Protection Company, Inc. Gets granted the diversion, he'll be on probation for.
He's got
Oh,
criminal
well.
charges.
Well, then I'm withdraw that. I didn't understand that.
So you're withdrawing your motion?
I am.
Okay.
I didn't know he was still on probation.
All right. Well, I would make a motion to deny him.
I'd second that motion.
We have a motion by Mr. Cockcroft and a second by Mr. Harvey to deny this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed?
I need the grounds. Just,
Criminal,
I know that, but you need to say based on poor moral character.
poor
or
moral
something.
character.
Okay.
That'll work.
I just have to put it.
That's no problem.
So, That goes with K6, okay? We're ready for K7,
Okay.
which is Jones, file number 32193. Jones disclosed 1980 public intox and possession of marijuana. 1982 delivery of a controlled substance, cocaine, and possession of marijuana. Another charge in 1982 for possession of cocaine. And then in 1989, a DUI, 1999, a DUI, and 2010 and 11. 2010 was a DUI, 11 was public intox. No charges since then. He's got an explanation for each. This did not want to scan very well yesterday, so if you're missing a page or something, let me know and I'll read it to you. He hasn't had a drug charge since 1982. Technician, app came in December the 5th. Mississippi.
Working in the alarm industry out of the state, I guess,
If he has been, it's been in Mississippi.
because he says it's for 15 years.
Yeah.
Well, again, I mean, he resides in the company he works for is located in Mississippi, but they have a Tennessee license. Hadn't had one of those in a little while.
Letter, they don't really recommend him.
I haven't gotten there yet. I guess I'm still in the criminal history.
You know, I don't know. The guy that wrote the letter owns the company. I will tell you that. And he's just recently gotten the company, and I'm not sure how excited. And again, when I tell them to write a letter to go with I don't think they know what to put in there.
Double D used to be out of the Tri-Cities.
No.
Yeah.
It's not the same company at all. No, Karen. It's
There
not.
was it was the same name.
It might be, but this is a guy out of Mississippi.
Got you.
He named it after himself. His last name.
I just wondered how.
think he's had his Tennessee license about a year.
Driver's license? Oh, the company guy's had his company license about a year. I'm sorry, I'm up to here in driver's.
We're almost done. We'll get there.
I'd make a motion that we grant Mr. Jones his employee registration.
Second.
Okay, we have a motion by Mr. Harvey, a second by Ms. Jones to grant this employee registration application. All in favor, voice by saying aye. Aye. All opposed? Motion carries.
Now, we will move to K8. Pearson, file 32212. All right, Mr. Pearson has several pages of disclosures regarding charges starting in 1978 and ending in 2012. Is employed, it's a girl. She is employed as an alarm monitor for a central station in Knoxville. Shoplifting or larceny, which she says was dismissed in 78. Public intoxication in 91. 97, simple possession and possession of paraphernalia. 2000, a DUI, possession of drugs without a prescription. And 2012, domestic violence. But I don't see any court records that would identify that. It is dismissed, but I couldn't find that on the paperwork. I'm not nearly as good as Vivian is at looking at some of this paperwork. Notice the letter from the qualifying agent actually lists all the charges that were disclosed.
Her as a monitor. Make a motion that we grant application A8 their registration.
We have a motion by Ms. Jones to grant this employee registration application. Do we have a second?
Second.
And we have a second. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Exhibit is K9. Perkins, 31013. Perkins disclosed 1992 underage consumption. That one was expunged. A 97 DUI, that was a conviction. 1997 simple possession, there was a conviction in jail and fines. 1998, contributing to the delinquency of a minor and misdemeanor theft. That was a conviction that resulted in 5 days in jail. 1999, driving while license revoked. That was a conviction. 2000, Mammoth Lakes, California, grand theft, money/property. They were convicted, spent 3 days in jail and 36 months probation. Leaving stolen property charge was dismissed. But the last charge was in 2000. Explanation seems to jive with the paperwork that. Also a Central Station employee in Knoxville at ADT Central.
Out of the time that's passed, I make a motion we grant Exhibit K9 there.
Second.
Okay, we have a motion by Ms. Jones, a second by Mr. Cockcroft to grant this employee registration application. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
The last record we're going to look at for this part of the program is Exhibit K10, White, file number 30529. White disclosed 2007 petty theft. And then the court records show petty theft of 100 or more adjudicated guilty May 7, 2007. Apparently for shoplifting at Walmart. Person is employed at a central station in Florida.
Motion would grant Mr. White his employee registration.
We have a motion by Mr. Harvey. Do we have a second?
Second.
We have a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Thank you.
Is that it? We got,
All we have is the education report.
good.
Unless you've got anything under new business or unfinished business. Are we ready for the education report? Okay. I'm asking if we have any. I don't have any.
Oh, we're talking about these things. Is that unfinished or not on
Oh,
the
as
record?
far as,
That's gotta go through the commissioner's office. I've
Okay.
tried to ask about that. I haven't gotten an answer yet.
we
Then I
talked
don't
about
have
just sending a letter or something, and we like having a, best thing.
I mean,
She was
these,
gonna
these
talk to
motels
somebody.
are taking us at our word that we're here for.
I can send each hotel a letter.
I never had anybody ask, but of course I hadn't.
It really just depends. Again, I know y'all would like to have a state ID like you. Why don't you send me an email, Scott, and state that? If you send it, then I'm gonna forward it to the rest of the
Okay.
board members, and then I'll take that and send it up to Linda Goodwin to have at the commissioner's office.
It works.
Marvelous.
Now, the courses. Exhibit L. And I know I sent all these out before the meeting, but Keith and Scott were nice enough to look at them again this morning. There were 15 Seymour courses submitted. Most of them are 1-hour courses. There was one 2-hour course. I can read them into the record. I really don't think I need to, but I will if you want.
Are we gonna vote on them in block?
I would vote on all the Seymour courses in one block. Keith, did you see any problem with approving the 1-hour
Not for
continuing ed?
1 hour CEUs, no, they were all good.
Or we can just make recommendations and make one motion at the end.
Why don't we do that and then attach this to the, as an exhibit or whatever?
I'll type it into the minutes, the names of the
Okay.
courses. The other course that was submitted by Greg Sieber was a Hakshiki FireNet application, 2-day training. He wanted to use for his continuing education. Did anybody have a chance to look at that?
It looks good. I mean, it's not the course information, but it's related to fire alarm installation. It looks good.
It was only 16-hour course. There was only one there. And then Tom Detman submitted a Mike Holt seminar, and there were 2 certificates, but one was for one state and one's for Alabama. It was a business skills and changes to the NEC 2014 seminar offered by Mike Holt.
I looked at that, but I had a question for you. In his letter, that he attended a week-long seminar. Then at the end, he said it was a weekend thing. Well, he said both. He said it was a whole week, and then he said it was a weekend. So
It was a
I did look at the course.
16-hour course. The certificate says 16 hours.
yes,
on
I
it.
seen that.
The
looked
concern I've
good.
got is that it's really good instruction, but
Yeah.
most of it is about electrical. I would doubt that there was very much about fire alarms, which is, because he even says I guess it satisfies his electrical license, or he holds several master electrician licenses, and it satisfies some of those. I would just doubt if it had much content about fire alarms. We had somebody else that submitted something about sprinkler systems that was like the installation of sprinklers, and we didn't approve that because it wasn't about fire alarm. Now, some of the NEC code would cover fire alarm, but I bet there wasn't 16 hours there of fire alarm related material.
I looked
Well, I mean,
at
there's
it. I
not-
thought it looked good.
There's not
It
really
just-
any information, it's just certificates.
It wasn't fire.
I printed out some information from Mike Holt's website on what the course
wasn't fire specific, but you would use all of it if you was going to install
Like Holt
fire.
does a lot of training for electricians.
He does a lot of our stuff too. A lot of the electrical stuff that we use on our exams is some of the Mike Holt's.
And I've got 2 or 3 books by him. I'm going to make a motion that we grant his application for that course. did look at it.
He just won't continue to ed for it.
Yeah,
He just wants to renew.
continuing
He
education.
expires the end of this month.
I didn't know
It
he
shows
did
the
a
outline. Did
Do
you
you
read?
want it to stay at 16, or do you think it's better at 8?
Did you read the outline?
I didn't see
All
it.
of it?
No, I didn't. I don't know that I saw an outline. I just saw the certificates. The
I just sent you a link to the website. I think I sent a link to Mike Holt's website showing what that course was about. I don't think I
saw more
printed
information
it.
about it. And you're comfortable with it. I'm
Hold
good
on.
with that.
I gave you all my
I looked
original
at it
paperwork
because
this
I got his
morning.
book and I like his book.
So far the recommendation is to approve. Any change?
You're gonna leave it at 16? Okay.
Now we need
Make
a motion to approve all of them.
all of them as
As
presented.
I make that
So
motion.
moved.
Okay. We got a motion and a second to approve these as presented in mass. All in favor, voice by saying aye.
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 Do.
All opposed? And these are on continuing education
They're all
courses.
just continuing ed courses. There wasn't anything else submitted.
Okay, that's that.
I do not have any further business that I'm aware of.
Do we have any new business? Any old business? Any unfinished business?
Scott's gonna send a letter to Beth, and then we're all going. Maybe if we all sent you one for these things, it might help.
Well, that's kind of why I was gonna forward it to you guys and then come up with a consensus.
All minds clear till next March? Merry Christmas, and we're adjourned.
Why are we waiting so long to the next meeting?
Well, because we only meet every 3 months.
We don't meet every other month
3 month
anymore.
rotation.